good morning, good morning, good morning, good morning, good morning to everyone in here. Welcome to Infamous Sylvia. Today I have my special guest, attorney Jamahl Kersey. He is here, guys. I'm going to bring him in so you guys can say good morning to him. Hold on. Good morning.
Good morning. How you doing?
I'm great. How are you doing?
I'm doing well. It's nice and early over here, 7:30. So I was up. I was up nice and early. Got out of bed about 3. So got my coffee in. We're ready to go.
Did you get a chance to listen to the hearing this morning?
I didn't, to be honest with you. I had a lot of transcripts to go through.
Okay.
You hit me with almost 1,000 pages.
I'm sorry.
No. It's all good. Actually, a lot of people had been asking me, because I've posted a few videos on the situation. People are like, have you actually seen the transcripts? Have you read the transcripts? And up until that point, I hadn't. But I still had a good amount of information to draw from. But now, having read the transcripts, that changes things. But yeah, I mean, to go through that many pages of trial transcripts definitely takes hours. So I wanted to make sure that I got through that so that we could have a conversation based on the actual facts as the jury heard them.
Yeah. And also, I want to apologize for getting that indictment to you at the last minute. It slipped my mind that I didn't get a chance to send it to you, but I apologize. There go Mr. 444 Smiles. I know you spoke with him.
Good morning, brother.
Hopefully he'll contain himself today.
We'll see. That might be a tall order, but we'll see.
444, go ahead on. Hopefully he'll contain himself. You might have to turn your mic down.
Me?
No, him.
Oh, okay.
444, because I hear some feedback.
I hear an echo.
All right. So I guess we can get started just to tell us a little bit about yourself, and then I'm going to let you take it over because I know you're the teacher.
All right. Yeah. So again, you introduced me. My name is Jamahl Kersey. I'm a criminal defense attorney in San Diego, California. I've been practicing 12 years, so I'm in my 13th year. I've handled all kinds of criminal cases from, major federal drug charges, high-profile homicide, sexual assault cases, defended multiple people facing life in prison. So when it comes to, the most serious offenses, I definitely have experience in that. In addition to cases involving, sexual assault allegations or statutory rape charges where you're dealing with, adult males having engaged in sexual activity with minors. So, all across the board when it comes to, criminal defense, there really isn't anything that I haven't touched at this point.
Okay, great. And 90% of my subscribers are Kelly supporters. And one of the reasons why Mr. 444 had reached out to you is because he actually saw some of your videos and he thought you would be a perfect person to try to explain a lot of the legal things that's happening, because we don't know. Because I personally, I'm gonna just tell you, I'm a lay person and I don't know, but I'm a sponge and willing to learn everything it is in regards to the law. The thing that really have us really in this like a shock, a disbelief, is the whole verdict of Mr. Kelly. And we don't understand how can 12 jurors come back with that type of verdict. When I was at the court and I heard the testimonies and inconsistencies and all that, and I'm like, okay, I need some answers. I need someone to help me understand some of this stuff. So that's why I'm asking for your help here. So
great. No, and I appreciate that preface. And, I got an opportunity to look at some of the videos and some of the content on your channel. So I'm well aware I'm talking to a crowd of R. Kelly supporters. And so, and I was talking to Mr. 444 Smiles the other day, and he knew, hey, listen, I saw your video and you were talking about you were a fan. So I absolutely am a fan of the artist and his music. You know, you really couldn't go anywhere, you know, any high school graduation without seeing or hearing "I Believe I Can Fly." I was in my high school choir and we sang "I Believe I Can Fly." You know, going all the way back to Public Announcement. You know, the first R. Kelly album and everything. So I definitely, you know, and as a musician myself, I grew up playing drums and I'm a DJ now. So, you know, as a musician and a creative, I can certainly respect the craft and understand the love that people have for R. Kelly as a musician and just as an inspiration overall. But what I do really appreciate in terms of what you just said is that you know, you're a sponge and you're looking to get, you know, information, and even though, you know, it's not likely that I'll say a whole lot of things that you know, appease you or that, you know, maybe you agree with. At the same time, you know, I'm looking at this with my legal mind as an attorney, and you know, when I'm looking at this indictment and looking at what it was that the government was alleging and what they were saying that they were going to prove, and then ultimately, when you have a jury deciding, okay, well, we're going to, you know, find him guilty on all counts, then on some level, they came to the conclusion that the prosecution did what they said that we do and proved, you know, each of these counts beyond a reasonable doubt. Now, I had a limited universe of transcripts, so you know, I've had the testimony of a few people. Jane Doe number 5. I don't know what her real name is. One of her friends, and I believe a music engineer, and then the pastor, not the pastor who married R. Kelly and Aaliyah, but a person who was a pastor and ultimately made the recommendation in terms of somebody he knew that could marry these two. And so so you know, to be honest with you, you know, given the background that I mentioned in terms of, you know, having grown up with this man, and he was, you know, he has writing credits on the soundtrack, you know, of our lives. It is sort of, I don't know, it's hard to describe the feeling when you look through this stuff and see the allegations, and also knowing a bit about his past and everything that he went through. It's almost surreal to see this stuff. But anyhow, to dive into some of these legal issues and be able to provide some light that I suppose a lay person wouldn't necessarily readily understand, we can get into that. And so, and I saw the interview with the I believe Mr. Magano, was it? The appellate attorney. I watched some of that, and he did an excellent job explaining the appellate process and what happens after you have a conviction and what a person's rights are to attempt to challenge a conviction. And obviously, you know, after Mr. Kelly is sentenced, they will then, you know, file their notice of appeal and then go through that whole appeal process in which they challenge, you know, whether it was specific rulings by the judge or any prosecutorial misconduct, or just believing that the wrong or the improper result was reached. But anyhow, you know, discussing the Mann Act, and that was this is probably the first time that many people have ever heard of what the Mann Act is. And so the Mann Act is actually a very old law. It was passed in 1910, and basically the Mann Act made it a felony to engage in interstate or foreign commerce and transporting any woman or girl for the purpose of prostitution or debauchery or any other immoral purpose. And actually the original you know, purpose behind it was to basically, you know, the country was in a process of imposing morality, and so this was really, you know, generated in order to combat some of the prostitution that was going on. And so, you know, what they wanted to do was stop the forced sexual slavery of women. And so over the years, it was used, you know, famously against Jack Johnson, who was the boxer who was, known for sleeping with white women. And so essentially, him taking his girlfriends or lovers across state lines and ultimately, having sex with them or otherwise having relations with them, they were able to use the Mann Act to prosecute him for, for that crime, or I'll say quote unquote crime. Ultimately, I believe Donald Trump ended up pardoning him posthumously, but ultimately, if the most simple form of this would be, if you when they say engaging in interstate or foreign commerce, basically that just means crossing state lines. So if you are in a vehicle and you are going from state to state, then you are, basically engaged in an activity that affects interstate commerce. And so, if you are crossing state lines and committing some sort of offense, then that has to do with either prostitution or committing some sort of immoral act, then arguably you're in violation of the Mann Act. So we'll just take that and we'll maybe dive into that a bit more. But the other issue that comes up is this racketeering and enterprise. They allege that there was a criminal enterprise essentially, and so we all know that R. Kelly was, at the height of his fame, a worldwide legendary artist, touring in the United States and throughout the world. And so there was you could say, just putting anything criminal aside, he had an enterprise going on, which was, they were engaged in the purpose of music promotion, right? So, there's accountants, there's, drivers, you have runners, you have security, you have engineers, you have managers, all these different people that assisted him for the purpose of promoting music. And so they did that. You have street teams, all these different type of things. But in enterprise, and enterprise is actually defined within federal law, and they just say any individual, partnership, or corporation, association, or legal entity, and that's an enterprise. And so then there's going to be a specific purpose for that enterprise. And again, the primary purpose for R. Kelly's enterprise was music promotion. But what the government was also alleging was that there was another purpose that had to do with recruiting women and girls. And so one of the major differences that you would find in in this situation, in terms of what the allegations are versus a normal sexual assault case or statutory rape case, is that, let's just say you had an adult who was attracted to younger girls. And, I had mentioned in one of my other videos, perhaps an uncle who, exploits or breaches the trust of his family and has sexual conduct or sexual activity with a niece, right? So, he's always at the house during, family gatherings and everything. Obviously, as a family member, there's a level of trust with him being there, and he's able to take advantage of that situation. That's going to be a one-off. There's generally not going to be any support for that person to do what it is that they do. They're only acting on their own. So when we compare that to what the government is alleging, that, hey, taking advantage of, being at concert venues or, appearances at other places or wherever it was, and having a system, if you will, to recruit women and girls. They one of the witnesses testified that they had a stack of little sheets of paper that would have either handwritten or typed out, R. Kelly's phone number or a number that he could be reached at. And so what they would do is, whether they were at the mall or wherever they were at, if R. Kelly saw someone that he liked, he would then direct them to pass them the information. And then once they had the information, they could then call in. And if R. Kelly wanted to arrange to have them come to meet him at a tour stop or at his studio or wherever it was going to be, then he would use his team to coordinate, to coordinate travel. So we're booking flights, we're booking hotels, we're providing for their food, lodging, everything. So this in this sense, it becomes much more, because we're talking about nationwide, in terms of where these activities were alleged to take place. So it wasn't something that he alone could do on his own at that scale. So you had to have an enterprise supporting. And I understand, this has been a bit controversial in terms of how people are saying, how could this be considered an enterprise? But again, an enterprise under the federal definition could just be an individual. But in this situation where you have a whole team of people, yes, who actually had legitimate jobs, again, as a driver, as a security, as a manager, yes, they can be operating in that way, but they could also be working for another purpose, which again, the government's allegations were to recruit and women and girls. And so that's your breakdown of what the enterprise is. The other issue was racketeering. All right. And so when you normally think about racketeering, you think of Al Capone, you think of John Gotti, you think of mafiosos, right? And you think of them engaged in illegal activity. So racketeering can cover all kinds of activity. Ultimately, you can have numbers. So people, doing illegal gambling. You can have drug racket. So if you're, cartels, manufacturing drugs, distribution of drugs, excuse me. You can have human trafficking. So labor trafficking, sex trafficking, there's all kinds of different racketeering activity, but ultimately it's an umbrella for an enterprise, engaging in illegal activity. And so in this situation, even though it's not your, it's absolutely not your traditional use of the law regarding racketeering, it ultimately fits. And they were able to successfully allege that each one of these acts, so there were, looks like there were 12, I believe, 12 racketeering acts alleged, including sexual exploitation of a child, bribery, kidnapping, Mann Act violations. So they were basically saying, in terms of this enterprise that we've now defined for you, these are the different acts constituting racketeering that this enterprise engaged in. And so that's sort of the general overview of what this case involved in and how we get there. So you have an enterprise, the enterprise is defined, and then they're saying that the enterprise essentially engaged in racketeering. I think one of the other things that makes this unique, going back to the example of the one-on-one situation of, just using an uncle and a niece, and then, that sounds absolutely horrible, but it's just an example that people can relate to. Compared to that, again, when we go back to the enterprise example, typically everyone would be benefiting from the enterprise, right? So if you are engaged in, a drug trafficking enterprise, then, everybody from, drug mules to people, making the drugs, manufacturing the drugs, to actually being on the street selling, to, wholesalers, to, distributors, to, the head of an organization, they're all profiting financially, right? So everyone stands to gain. Everybody involved stands to gain. In this situation, really, everyone had an actual job. Again, so if you were a driver, you drove, and presumably that's what you were paid for. You were paid to drive, or you were paid to run errands, or you were paid to be a studio engineer. But really, when we're talking about these sexual assault charges, the only person who stood to gain from that is R. Kelly himself. And so that also makes this a little different from your traditional racketeering case. But there's not necessarily any requirement that other people stand to benefit from it. One person alone could benefit from it, provided you have an enterprise and they're engaged in racketeering, which again would be essentially any pattern of illegal activity. Then there you have it. And so we can get into some specifics, but I want to, I've kind of said a lot already, so I want to see if there's, any questions or follow up that you guys might have on that before I get into some of these specific issues.
Okay. As far, because I do have a question, as far
Sure.
as like the Mann Act and also the racketeering, putting it together as some sort of sexual activity, there's prostitution. I'm just going to say prostitution, right?
Mm-hmm.
That means even like sex trafficking, that there has to be somebody who's supplying the girls. So why aren't they also being charged and prosecuted as well? I'm talking about more in terms of the parents, because the parents were supposedly benefiting from R. Kelly.
No, I understand the question. That's a good question. But in terms of Mann Act, so Mann Act, and let's just say generally sexual conduct with a minor, you don't need any particular supplier for that, right? So if person A, person A is an adult and engages with person B, who's say 15 or 16 years old. He's in the state of California. He takes her to the state of Arizona, right? And at some point has sexual activity with her. However they met, whether he met her at a cheerleading rally or at a high school or where at the mall, there doesn't need to be anybody else involved for him to realistically have violated the Mann Act, or for him to have engaged in statutory rape. I think what makes this situation different is that there's a volume and there's a whole host of activity behind this that makes it different from that one-on-one situation. Because again, you probably normally wouldn't have a situation where that person that I just described is taking that person, across state lines, because they probably, generally speaking, wouldn't have a reason to cross state lines to do what they were doing. He'd probably, take the girl to his house or wherever they would do, what they do. So, but in this situation where, not only do you have these, because if R. Kelly's on tour and wants to see these different girls or get girls from different states and the like, then now you have something where this is becoming a federal issue, because and that's one of the other issues to discuss is normally when you have, whether it's a kidnapping charge or a sexual assault charge, those are usually state cases, and they're usually just prosecuted within the states that they're in, because they're state offenses. Most offenses, most crimes are state offenses. There are very limited situations in which a crime that would otherwise be a state crime would then be a federal crime. So certain federal crimes are, any state offense that occurs on federal property. So, say on a military base or anything else that would be designated federal property. Also, and this is where you see the language where it says, affecting interstate commerce. So that's the commerce clause of the Constitution. And that's what can make a violation of state law turn into federal law. So generally speaking, let's just, say as an example, drugs. If, somebody's rolling down the street and they got a brick of cocaine in their trunk, and for whatever reason they get pulled over, they got a busted tail light, cop pulls them over, asks if they can search the vehicle. They search the vehicle, find the brick of cocaine. that's going to be a violation of state law. So, in California, that would be, possession for sale of cocaine, based on the volume. I mean, if you had a brick of cocaine, it'd be hard to say that's just for personal use. So that's going to be, fall under California's drug trafficking statute. But if that guy, instead of California, so he started his journey in California and he gets pulled over in Texas, now that's now become federal, because you've now crossed state lines in order to commit this offense. And so you're engaged in an act which affects interstate commerce. Again, the crossing of the state lines, that's what makes what would normally be, if you're just traveling through a state, that's going to be a state offense. But the moment you cross state lines, that's now going to be federal. And so generally speaking, federal, the feds aren't even going to necessarily get involved unless it is a bigger situation. So again, the government, obviously the federal government, trying to, send a message. And sometimes, unfortunately, people have to be the fall guy for, when the government is sending messages. And so in this situation, they're saying, we're just not going to be we're not going to be tolerant of, sex trafficking or, sexual assault on this scale. We're not going to tolerate people abusing their positions of power and authority and fame and wealth in order to, engage in this type of activity. So I think the issue that you raise is certainly worth addressing. And so, I'll just kind of dive into that now. Looking at what I've seen in terms of the conduct of parents in this situation is disgusting. Just, I mean, there's no other word for it. I don't have children yet, but I do plan to have children someday. And I have plenty of nieces, and to see how, parents may have been using their children for financial gain, for status, for fame, or whatever it is that they were going after, and using their children as pawns in that sense is, reprehensible and just disgusting. And I think, perhaps something should be done, about that criminally. It's not my place to decide, but, for if all that stuff is true, then, it's disgusting, but it doesn't, it doesn't absolve, Robert Kelly from his activity. And so when you think about, and so just to be a bit more concrete about that thought, let's just say, if the parents did, set up Robert with this situation. So knowing that, perhaps he has an inclination towards younger women, and then ultimately saying, hey, well, let's set this man up so we can take advantage of the situation and blackmail him, or try and get money out of him, or otherwise set him up to where we can sue him civilly, or whatever the situation is. In that situation, a person still, has their own personal responsibility to make sure they're not in violation of the law. And so when we're talking about,
Jamahl,
again,
Jamahl, I do have a question.
Sure.
The parent, I don't know if you got the part where I sent to you, where her mother was acting as if it was her, texting Mr. Kelly and saying she was 18 years old.
I did.
And each time they validate her being 18. So to me, he did everything that he could. He asked for ID and all this stuff, and they lied.
Yeah. So the mom, I did see that transcript, and the mother was, had initiated contact with Robert Kelly. I believe the Jane Doe that was, I think it was number 5. She had said that she had the wrong number, right? So, I mean, she tried to reach out had the wrong number, but then somehow had gone to her mother's phone and saw that her mom was already, texting back and forth with Robert, saying that she was 18, right? So the initial in Robert Kelly's mind at that time, he was engaging with somebody who was 18, right? And then when that meeting is coordinated, they meet up, and I don't remember if there was another discussion at that point
It
as to
was
whether
at the hotel when the police came.
right.
The police.
No,
showed
so I'm going to
ID.
get to the police, but I'm
Okay.
saying I don't know if between them, I mean, it really wouldn't make sense for them to, talk about that again initially. If, presumably if he's thinking he's talking to the girl, but he's actually talking to the mom, and she had already said, hey, I'm 18, there wouldn't be a reason to have that discussion again. But yes, the police do end up showing up, saying, hey, this girl's parents are looking for her. What's going on? And she tells the police that she's 18, right? So she tells the police that she's 18. He obviously is hearing this conversation, and in his mind at this point, it's just another affirmation that the girl is 18. And she actually produced a license or some sort of ID to the cops, and they were, ultimately satisfied and left. So when you think about that, I mean, there's two different ways that could go. Obviously, if because she was already 17 at that point. So, I don't know how much the officers would have looked and done the math to calculate whether, she was in fact 18, or if they looked. So two things are possible. Either, she had said she was 18 and they saw the ID and it was like close enough. And they're like, okay, well, she's 18. Or they knew, that she based on her license was 17 and just chose to disregard it. But, let's just believe that they believed that she was 18 based on her saying that.
And
The
they
ID.
called the parents, and they talked to the
Right.
parents on the phone.
Right.
Was that grounds to cross-examine the mother? That's what I want to know. Was that grounds to cross-examine the parents?
For who to cross-examine the parent?
The defense, because of them text messages and the correspondence.
So, I mean, if they wanted to call her as a witness, to testify as to whether she did in fact say to the police that their daughter was 18, I suppose she could be called as a witness to corroborate that or say what did or did not happen. But she wasn't called, right?
No, she wasn't called, but and the judge wouldn't allow her, so that she should have been allowed to answer those 3 questions, right? Because she's in a discovery.
Without seeing the specific ruling in terms of why her testimony was excluded, I can't necessarily offer an opinion on that without seeing that. But I would think that, if it's obviously in evidence that there was some sort of conversation between the mom and the police, because, she would have called 911 or called the local authorities saying, hey, we don't know where our daughter's at. We need you to go out and look for her. And then there also was testimony that the mother or that the mother spoke to the police, either the mother or the father spoke to the police and said that she was 18. So I would think that the mother should be able to be called as a witness and say, yes, I said this, or no, I didn't. But, in terms of why that didn't happen, I'm not certain. But, so back to the point. So we have at least a few communications to Kelly that this girl was 18, right? And so, but what then happens a little later is that she says that she told him that she was actually 17. And so we had 2 different versions, I suppose, because on cross-examination, they tried to establish, that it was that she said that she was 17, and then he sent her home and basically didn't want to have anything to do with the situation. But nonetheless, what ultimately came out was that she said, hey, yeah, he would have believed that I was 18 based on the text that my mom sent, based on me telling the cops I was 18, based on my parents telling the cops I was 18. But at a certain point, while I was 17 still, I told him I was 17, and essentially their sexual relationship carried on. So arguably, I mean, you couldn't, well, if a person does engage in if an adult engages in sexual conduct with a minor, then you're technically in violation of the statute. There is a mistake of age defense, right? So if it were just this one person, then at least everything that happened up until she told him that she was 17, then he would be able to say, hey, listen, I had every reason in the world to believe she was 18. When she first texted me, he didn't know that it was a mom. When she first was texting me, she said she was 18. We had an incident where, the cops came through. She told the cops she was 18. Her parents, told the cops she was 18. So, that would be a solid mistake of age defense. But, you can only use a mistake of age defense, until you are made aware of the truth. And so once you have testimony that, the alleged victim made you aware that they, in fact, were not 18, that they were 17, even though there were, a series of lies beforehand, you can't still then hang on to the prior information and still be like, oh, no, I thought she was 18.
But Jamahl,
so yes.
But the question is, okay, by the time she told him, she was in a state where 17 is a legal age.
I understand that, but he wasn't charged in terms of that particular Jane Doe. I don't believe he was charged with anything in Illinois. So, but in California, it's 17.
It's 17?
So
she was 17.
No. So 17. I'm sorry. It's 18.
18.
So
but wouldn't that mistake of age be applied to California at that time frame? Because that's when he supposedly had sex with her, supposedly alleged.
So again, if he was aware, at that point, again, and the law is that as an adult, you cannot have sex with anyone who is under the age of 18. That's the law. Now, again, there is a mistake of age defense where again, if there was a mistake in age, then you can testify to that, and that's what then becomes a major issue in this case, because we're not just talking about one girl, we're talking about multiple. And I know at this point, when they're testifying, they're women, and so people are saying, where are the girls? They're testifying as to things that happened years ago, right? So when they were underage.
The other one lied also.
Okay, so I mean, I'm just explaining, how you have a grown woman saying that she had sex with this man when she was underage, and how that ends up being a thing. So when you have that situation, again, when you have multiple allegations of this, that's where it makes it that much harder to say that it was a mistake or I didn't know. If it's one, it's like, okay, but if it's if it becomes multiple, it becomes all the more challenging. And that's not me judging him or anything. I'm just saying, in any case that you're talking about, if you have just one allegation, it's going to be a lot easier, or it's going to be less of a challenge to defend than if you have multiple people, essentially saying the same thing. Now, I know that's going to bring up, oh, well, people were coached and all that. I'm just saying, generally speaking, it's going to be, less of an uphill battle to defend against one allegation versus multiple people. But when we're talking about mistake of age defense, the defense team did the best that they could. I'm sorry. Well, let me finish this, and then you can say whatever you're going to say. The defense team did a solid job, or as best as they could, in terms of pointing out inconsistencies pointing out reasons why people had to make stuff up, whether it was book deals, parents being involved, financial gain, or what have you. They were able to bring that stuff out in order to did what they could to create reasonable doubt as to whether he actually knew that these girls were underage. But and we talked about this on the phone, when you have a mistake of age defense, the best person to tell you what their state of mind is or what they knew at any particular time would be the person who's accused themselves, right? So for that person to take the stand and say, hey, listen, on this date, this is the age that I thought they were based on, XYZ information, or, they didn't tell me this until X date, or, parent told me this, they told me that, and they're able to tell themselves, because otherwise you're limited to attacking the credibility of these alleged victims or any other witnesses versus hearing from the horse's mouth what the person knew or didn't know at the time. So when you have that issue, that's, and obviously they elected not to put Kelly on the stand. And you have two different camps or trains of thought when it comes to putting a witness on the stand. I'm just going to finish this thought and then you can throw that question at me. But some defense attorneys say never put your client on the stand unless you have to. And other attorneys, myself included, say always put your client on the stand unless you cannot. And so I don't know what this defense team's what camp they fall in. If they say, well, never put on your client unless you have to, then they didn't feel like they had to and elected not to. Or if they're in the camp, they say always put your client on unless you can't. Perhaps they wanted to put him on, but for whatever reason felt like they could not because it just wouldn't be good for the defense. But ultimately, those are the type of things when you have a state of mind that the best witness in terms of the defendant's state of mind is the defendant themselves. And so that's where if this was the case that he didn't know or there was some doubt or anything like that, then he would have been the only person who would have been really able to clarify that. But again, he would be subject to cross-examination on a whole host of issues that he probably would not have wanted to answer to. But yeah, what's the question?
It's basically like if 10 people say you're a horse, you're a horse in that sense. Basically, if everybody's saying you're a horse, or 10 people say you're a bird. If you're saying that, it's the story, it's not that you've been coached, it's what 10 people say consistently. Then if 10 people could say something consistently, it goes back into that moniker. If 10 people say you're a rat, you're whatever you are, you not. If 10 people saying it.
I mean, that's a statement. Is there a question attached to that?
Yeah, I'm saying. So I said, is this like is he being charged in the form of, because it's not being coached, but 10 people saying the same thing. So if 10 people say the same thing, basically they could charge you with that act.
Well, I think a prosecutor or the prosecutors in this case would say that, it's just consistent acts, right? So they have, if it's 10 people or whatever the number is, 10 people can have experienced very same or similar things. And obviously, like I was saying before, the more people that you have saying same or similar things, then yeah, I mean, it's going to make a jury believe that these things are true. But at the same time, they have to have looked at each and every separate one and ultimately found there to have been a violation on each count. So you can have, and any attorney who has defended a case, you may have a situation where your client is charged with 20 counts and they may be very similar, but say one or two are not found guilty. So and actually to illustrate that point, I tried a case years ago where my client was charged with, I think, 50 plus counts of burglary. And it was like the same practice. Somebody would knock on the door to find out if somebody's home or not. And if nobody answered, then they had their little team go through, pull the jewelry, whatever, get everything. And then they'd go to this jewelry shop where they would sell the jewels. In that situation, with all those 50, you start to hear the testimony, and it's the same thing over and over again with all these victims saying, yeah, I came home, X and X thing was missing. I didn't permit anybody to come into my house. They didn't have permission to take my things. And you start to hear that over and over again, and you can feel like, we'll just believe them all because, 50 people can't be lying. But actually in that case, there were at least 2, if not 3 counts where the jury found our clients not guilty because they felt like the prosecution with respect to those 3 counts, I don't remember exactly why, but that's not really important. But ultimately they found that my client was not guilty on those 3 counts, even though on those other 47, they found him guilty. So my only point in mentioning that is the jury has to look at, so for every charge, there's elements that has to be proved, and each one of those elements has to be proved beyond a reasonable doubt, and each one of those charges has to be proved beyond a reasonable doubt. Otherwise, they have to vote not guilty. And so, none of us were in, the deliberation room and heard those conversations, but we know based on the result, on some level, they found each of one of these charges to be true and ultimately, found him guilty. So I get what you're saying in terms of, if you say, I get the example, but in this situation, the difference between, rumors and if 10 people say that you're, a cheater, then someone might conclude, hey man, this guy might be a cheater. In this situation where you have, charges in a case, the jury has to consider each one of those, in and of themselves. But obviously there is a, umbrella of activity that the government alleged was taking place. So again, there's a lot of detail. I reviewed, like I said, almost 800 or so pages of transcripts. So there's probably thousands of pages that I didn't see, and I don't know what the details are in terms of, these witnesses' credibility. But from what I have seen, it appears that there's some credibility issues, and that's what the purpose of cross-examination is, for the defense to be able to either call into question the person's credibility, their perception, or their bias. So those are the 3 things that you're seeking to exploit on cross-examination. Again, credibility. So, are you telling the truth about what it is that you're testifying? Perception. Did you really perceive things in the way that you're saying you did or that you didn't? And then bias. So if there's any sort of reason why you would be motivated to say what you said. And so those are the things that you're attempting to attack. But cross-examination's really gonna only go so far. You also, so the defense had their opportunity to present their case. And interestingly enough, I saw some summarizations of the testimony of people who were working with Kelly, who said that they never saw, anything wrong. On the contrary, they saw that he was a gentleman with the women that he was around and all these different type of things. But one of the issues, again, back to my prior point, was that if you are saying that these things didn't take place, or if an element requires your state of mind, the only person who can really say, what a person's state of mind is the defendant. And so I also want to be abundantly clear. The law clearly says that, a jury is not to hold against a defendant his or her election not to testify. So you can't hold against that person their right, them exercising their right to not testify. But in the real world, rightly or wrongly, people naturally want to hear from the accused. So when you're in voir dire, which is the jury selection, a lot of times, you ask, if you already know you're not going to put your client on the stand, then you'll ask to see if a person will really follow the law and not hold it against your client because they're not testifying. Because that's something that people's natural inclination is to say, well, if I were accused of something, especially the more serious it is, if I were accused of something, I would want to take the stand and clear my name. And yeah, that might be your personal feeling, but that's not what the law says. The law says that a person has the right to elect not to testify. And so but realistically, human nature is that you want to hear from the person who was accused. You want to hear that person's side of the story. And so in certain cases, just say like a self-defense case, so let's say somebody comes in your house and you shoot them, or somebody attacks you in the street and you hit them back, or you stab them or whatever. You would ultimately have to take the stand in order to be able to say that, hey, I felt in fear of my safety, or I felt like my life was in danger, and this is why I acted the way I acted. So with those type of cases, you do have to have your client take the stand. But in others, it's not really necessary to have your client take the stand to present your defense. But there are some practical difficulties that you can have by not putting your client on the stand, and this is one of them. Where again, if you're based on your cross-examination, if you're digging out that people were lying and people were deceptive and people were motivated, all these different type of things, then if it's true that your client didn't know that the girl was not of legal age, then you would want to have that person take the stand and be able to say, I didn't know, and these are the reasons why I didn't know. And if the jury finds that reasoning to be believable, or they find that causes reasonable doubt as to whether they really knew, then they would have to find not guilty. But again, if you don't have your client on the stand, then there's can testify as to what your specific state of mind is. And again, when you have multiple victims saying that they were under 18 or under the age of legal consent, that's what presents some challenges in terms of that.
Okay, what I'm going to do is I'm going to bring everybody to the screen now, and then we can start with the question. Are you ready?
Mm-hmm.
All right. We're going to start with Terry, since he is the bottom here.
Good morning. You would put me on the spot. I told you, see, I'm busy. Good morning, my brother from the West Coast. I'm here. I'm here from the West Coast like you. I'm right here in Rancho Cucamonga. So,
all right. Nice.
Yeah. It's West Coast love over here.
That's right. That's right.
So okay, because you read the transcripts and
not all of them. Not all of
them. Okay, so he hasn't been part, because my question was going to be, with the amount of exhibits that the jury had to review and go over, even the testimonies from both sides, the prosecution and the rebuttal. Do you think from the time that the trial lasted and the time that the jurors received it and deliberated within less than 9 hours, do you think that they actually looked over all those pieces of exhibits and testimonies from both sides and came with a true verdict that they felt was right?
So to be clear, they don't get the transcripts of all the testimony when they're going back into the jury room. So if there's a question as to what a particular witness said, then they can send a note. They can send a note through the bailiff to the judge saying, "Hey, we'd like a read back of this testimony." So that's why they, when you see them scribbling away on their notepads, they're taking notes because they don't get a transcript. Man, if they got a transcript of the whole trial, I mean, for me myself, and I was taking notes, so I spent hours, just going through the the 800 pages that Sylvia sent me. So that would just take way too long. So ultimately, again, they're going to have their collective memory of what the testimony was based on their notes. And if they have a particular issue that they'd like to have read back, then they can get a read back. But they will get the exhibits. And so, I had seen the list, or at least a partial list of the exhibits. So they'll get the exhibits. And so to answer that question, would 9 hours be enough to go through all that information and ultimately make a decision? Yes, it would. I have had, I mentioned some of my federal experience of a major drug trafficking case years ago, in which the jury actually came back after like 15 minutes. Right. So the trial, it wasn't quite as long. I believe this trial was 6 weeks or so. This trial was maybe 2 or 3 weeks, but there was a lot of information. There was a lot of surveillance video. There was a lot of wiretapped conversations. There was a lot of photographs, a lot of testimony. But ultimately, that case was so strong that in 15 minutes, that jury came back. And so that was my first experience with those type of federal drug trafficking cases. I was actually working with a more seasoned attorney, and I was second chairing that trial. But yeah, I mean, if the evidence is strong, then I couldn't imagine in this particular case that the jury could come back that fast. But in that trial that we were in, jury came back in 15 minutes. And while I was surprised, because I'd never had that experience personally before, there really wasn't anything that I could be upset about in terms of, the jury's decision, because, based on the evidence that was presented, it was very clear that there was, drugs being manufactured, drugs being distributed and sold and the like. So, in cases in which the evidence is strong and there's not a whole lot that could be potentially found to be reasonable doubt, then yeah, a jury could come back, relatively quickly. I would have probably thought that the jury would be out for longer, maybe a couple days or so. But the fact that they came back in, just over 1 day doesn't necessarily mean that they didn't take the process seriously and really confer on the issues and ultimately, reach their verdict. So I don't think that the time in and of itself, indicates that there was any wrongdoing by the jury. No.
Okay. Now we're going to have Dottie to come next with her question. All right, Dottie.
Hello, good morning.
Good morning.
Can everybody hear me?
Yes, we can hear you.
Good morning. I guess my question goes back to, you mentioned the more victims or witnesses that come forward and talk about underage, or the more believable it is, rather than just have that one person testify, and then he says, well, it was a mistake. You said that if it's one person, it's more believable for the jury, rather. Because in this situation, what I'm getting at is there was only 2 underage people, and then the rest was pretty much like in the Cosby thing, it was more so uncharged events, hearsay. Do you? I don't know.
Yeah. So, just to be clear, you could have 100 people lying about something, right? And so that's what the purpose of cross-examination is. And again, the defense attorneys did the best that they could in terms of exposing potential motivation to falsify testimony and the like, they also are able to conduct their own investigation and present their own witnesses. But ultimately, these charges, whether it was two that were underage, I mean, if it's just one, I mean, that's enough for you to be found guilty of whether it's child exploitation or any of the statutory rape type offenses. So so they just and a lot of times with these federal cases, and given the who they're prosecuting, they want to make sure that they, from their perspective, get this thing right and not leave any stone unturned. So that's where you have this many witnesses. Again, I'm not familiar with all of the witnesses and what all they testified about, but but you do have these. So if there were only two that were alleged to be underage, and then the rest either had to do with that a kidnapping charge, or forced sex, or forced labor, or whatever the allegations were, that's, you just had the number of witnesses that you had. And so yes, it is a situation where if you do have more people, then that's what I was saying, is that it's harder to just say that one person is or sorry, it's a much harder situation to say that multiple people are lying or are in on this conspiracy to take somebody down, versus when there's just one alleged victim. And and that could be applied to this particular case. I'm sort of hesitant to do so without having seen all the evidence, but I'm just saying, generally speaking, you're facing a much you're facing an uphill battle if you're trying to say that all these different people are lying about a particular issue. And again, the way that because in any case, in any criminal case, there is nobody in the world who is more knowledgeable on the topic than the person being prosecuted. Why? Because if the police are investigating alleged activity, they're perceiving what they're perceiving, or if they're coming in response to a call. So let's just say a person ends up getting stabbed, they call 911. The police are responding after the fact, right? The police are responding after the fact, but the person who is accused, if they did what they're alleged to have done, they're the one that knows what's going on. And so again, that takes me back to what I've been repeating, is that in this situation, if he did not do if he really didn't do what he's alleged to have done, then he would have been the person to be able to clear up a lot of this information, but for whatever reason elected not to take the stand.
Okay.
I absolutely agree.
All right. Travel. No, sorry. Let 444 go. It's an order we're doing here. Sorry. Go ahead, 444.
I don't know what order I'm in.
Hold on. Now I'll let you in. Don't worry. 444. Come on in.
Now Travel the World can go ahead. She can go ahead. Go ahead, Travel the World.
No,
Okay.
444. You go ahead on, please. Let me handle this. Do you have a question?
Let me ask you a question. Being
Sure.
that these jurors are smart and they follow they follow the feds, and they know their tendencies, and they understand how sometimes you can get the same people to say the same thing. So now, when the lady said that she was crying, they made her cry. They did some hard tactics. So the jury is not going to take that in consideration, what they made her do, because they do have some tactics. So now, would they take that in consideration, knowing that they tactics and they play dirty? Do the jury understand that?
I'm sorry, when you said made who cry, like who made who cry?
They made one of R.
Who's
Kelly's
they?
sisters cry. The feds.
Okay.
They kept asking her. They had her in there for hours, and
Uh-huh.
then when they have you in there for hours and hours, you as a witness, you as a lawyer, when these people keep you in one place for 5 hours and keep asking you, next thing you know, that story starts to come to what you saying they said. A lot of
Mhm.
people saying that they told on themselves, but if you sitting there, you're jogging your memory this long, of course you're going to get it. So when people they was in there for hours and hours and hours, don't you think that they would eventually start saying the same thing?
So just generally speaking, because I didn't get any transcripts to that effect, so I don't know what that specific testimony was. But just talking on the topic of interviews and interrogations generally, and this is a reason why I tell people who are under investigation or actually charged with a crime not to give a statement to the police, no matter what they say, because if you're accused, or even if you're not, if you're just a witness that they're trying to get something out of, you're on the police or you're on law enforcement's home field, so they have complete home field advantage. A lot of times, it can be cold, it can be extremely cold, or it can be dark. It's just an intimidating environment, and to the extent that it does last hours, you can just be fatigued. So there's a lot of conditions that can make it a challenge for a person who is either being interrogated or interviewed. But when it comes down to that, yes, I do believe that leads to fertile ground for a defense attorney to point out, inconsistencies or lies or what have you. But what you would end up having to do is, if the person, as a result of that interview or that interrogation, they said one thing, then you would need to be able to present or otherwise have information to the contrary to confront them. And then you would point out how they would end up saying, what they said, because they were subjected to this questioning for so long and just badgering, that they ultimately just said what the government wanted them to say. But
That's what I want to
and I'm just
understand.
speaking in general. But yeah, I mean, you would need to have or it would be ideal to have the information to the contrary. Again, and when we're talking about this case specifically, that's where it would have been ideal to have Kelly testify, to the extent wherever there was any sort of lie said, from the defense perspective. If there was a lie said, then the best person to be able to say that this didn't happen or this didn't go down like this would be Kelly. And realistically, at least from me, I don't know how everybody else does it. But when when I have a client and they're charged with something, what happens is we get the discovery, right? So we get the police reports, witness statements, photographs, videos, any relevant documents, all the information that ultimately the government believes that they have that will prove beyond a reasonable doubt that my client is guilty with whatever he's charged with. I review that information. I then give a copy to my client to review, and I tell him or her, hey, go through, highlight anything that highlight, take notes, and tell me, is this true, is this not true, this is an exaggeration, this is a lie, this is true, this didn't actually happen like this. And we have our defense strategy session. We go through everything so that he can tell me, because at the end of the day, that he or she knows more than the cops, he or she knows more than any of these other witnesses, any of these videos, because they're the person that was involved in the situation. So they're able to tell you, how things really went down. And then you're able to use that, if you're not in trial yet, you're able to use that in your negotiations. So if your client is being overly charged, then if the prosecution just has it all wrong, because the prosecution doesn't know either. The prosecution is a lawyer, just like the defense attorney. So neither one of us were there when everything went down. We're taking what we have after the fact and putting together a case. They're putting together a case saying that my client is guilty. I'm putting together a case, raising reasonable doubt or otherwise saying that my client is not guilty. And then, in front of the jury, we see how it ultimately shakes out. So yes, witness questioning and interrogation, you always want to, and a lot of times you'll have a video of that, of that interview, and you'll be able to look and see, are the interrogators, are the detectives or the officers being overly forceful or aggressive, and pushing them into saying what they want to hear. And if that's the case, and you may even, depending on the situation, may have your investigator go. And I've had that happen in situations where, because backing up a little bit, when the cops are tasked with getting information or investigating criminal activity, generally speaking, they're not looking to find the evidence that proves that the person is not guilty. They're looking to build a case, and they're going to move to where to what leads them to that building of the case against the person. And so that's where you'll have their questions are drafted or made in a way that they get the information that they want. So it can be very useful to have an investigator. So I have my team of private investigators who will go and re-interview witnesses. And sometimes you get a completely different story from these particular witnesses when the investigator interviews them and they're like, no, I didn't mean it that way, or I didn't say it that way, or that's not what I said at all. This is what I really meant. Or this is how it went down. And you're like, this is night and day. And the difference is that, the private investigator isn't obviously looking to bury your client. They're on the defense team. So it's just a different, tone with which the conversation is carried out. So yes, I would agree that investigators, whether they're prosecuting investigators or detectives, officers, can be very influential in the manner in which they carry out their questioning, their interviews, their interrogations. But as the defense, you have to find where you can exploit those things. And, if it's a blatant lie, then ideally you'll have other objective evidence or other witnesses who can disprove that, or, find a way to, uncover their motive for being untruthful, or, otherwise being able to attack their credibility. So that's, and we saw a lot of that here in this particular trial. But at the same time, just to wrap up that point, a person can be a liar. A person can be, have an unsavory character, if you will, and they can, not even necessarily be a likable person, but they could still be, telling the truth about particular things. And so, that's when you're attacking these people and pointing out inconsistencies and drawing out things that would potentially turn the jury against those people. You could do that, but you still have, that mountain to overcome in terms of what they said happened and how it went down. And that, that can be a very tall order.
Okay. Travel the world.
Okay. Good morning, everyone.
Good morning.
I don't know if I'm put this as a statement or as a question. Maybe Dottie and Sylvia can help me out about the jury being sequestered. Okay, if they're sequestered, then all of a sudden they can go home, and then the next day they come with a guilty verdict. I mean, like, help me out, Sylvia. You know what I'm talking about.
It wasn't just the next day. They went home over the weekend.
Well, was the jury sequestered?
Yes.
Partially. It was partially sequestered.
Okay. Yeah, because I didn't think that they were sequestered. Obviously the jury, when they're deliberating, no one is allowed in that room, and only the bailiff, or I guess in a federal case it might be a marshal, is able to go in and communicate with them and what have you. So they're definitely isolated or otherwise on their own. But I not knowing what the terms of the sequestration, if they were sequestered, it's difficult to offer any opinion on that. Does anyone have any further details on that, on the sequestering of them?
They were allowed to go home every day. During deliberation, they were sequestered, like shut down by themselves. But as far, it was partially sequestered.
But by them,
well, what's the issue?
But by them going home, let's be realistic now. They could watch TV, video. I mean, their loved ones can give them information or this, that, and the other.
So I understand what you're saying. What is the question though?
wouldn't that make up their mind already, kind of sort of like?
So again,
Because
I mean, go ahead.
Actually, I believe they came in there with the mind already made up.
Well,
Thank you.
I can't say that. I don't know. Obviously I wasn't
That's why I
there.
said I don't know if it's a question or a statement.
Yeah, no, I mean, that's fair enough. If you feel like they went in there with their mind made up, then that's how you feel, and I respect that. But in terms of what you did ask about, yes, I mean, presumably they could talk to family members. They could go on social media. They could go on the internet. But the judge, is very specific in instructing the jurors. Don't talk about the case. Don't investigate the case. Don't do anything. So they're supposed to be in their own little bubble, so to speak, and in which the only evidence that they're supposed to be getting about the case is supposed to come from what the testimony and the evidence that they received in court. And I would say just overall, jurors are good about that. They take their job seriously. They take their roles seriously as jurors. It is a very serious environment, and people tend to hang on to what the judges say, and jurors tend to want to get come back right in terms of their decision. They understand the magnitude of their responsibility. But yes, I mean, you do have, every once in a while, we do hear about a situation in which a juror spoke to somebody they shouldn't have, or talked about something that they shouldn't have, and that ends up coming out. I think the last guest spoke about that, but I don't personally have any reason to believe that there was anything done wrong with this particular jury. And again, going back to that original question about the jurors' conduct, there's nothing in and of itself about the time that they spent deliberating that suggests that they didn't take the matter seriously, or that they just already had their mind made up. But I think and again, that kind of goes to the volume of information with which they were presented. At the end of the day, I mean, they sat through weeks of the prosecution's testimony, and then the prosecutor in closing has to tie up all those loose ends, because when you're going through when you're listening to this testimony, a lot of times it's not in chronological order in terms of the sequence of the witnesses, and so it can be very difficult to even understand, like, what's the relevance of this testimony? Why are we hearing from this person? And ultimately, okay, you take your notes, and then both the prosecution and the defense have to tie everything together in their closing arguments. And so I imagine ultimately, even though it was a lot of information, the prosecution, in tying their information together, they felt convinced, when they went into the deliberation room, that the prosecution had proved their case beyond a reasonable doubt. Sometimes that happens, but we're still talking about 9 hours. 9 hours. Again, I had said before, I would probably think that a jury in this type of case with this much testimony might have been out for 2 or 3 days, but 9 hours is not an insignificant amount of time. Obviously, they had some conversation in terms of, and probably they felt like the prosecution proved each case or each charge beyond a reasonable doubt, but in order to make sure that they were fully convinced that there was probably some of these defense issues raised. But ultimately, after having their conversation back and forth, they felt like the prosecution met their burden, and so here we are.
Okay, Daddy Lolo.
Okay, I got really pretty much two questions in exact. What do you have to say about the judge allowing the prosecutors to change the language in the jury verdict sheet to fit the prosecution's narrative, so that they can get a guilty verdict by changing the word "and" meaning "or" to making it mean "or," and And then also the other question is, what do you have?
Sorry, before that one, before the second question, what do you know what was specifically changed? Because I don't know what was changed.
The change was like, let's say like for the bribery thing, it said that you have to find him guilty of or like he knowingly bribed somebody and he paid off someone. So they changed it from and that he could do both of those things to or. Like it's either one or the other.
So, you know, and to be clear, these things, whether it's jury instructions or verdict forms,
And they
get
changed
changed.
they changed it while the jury deliberated.
So those things happen. You know, sometimes a jury instruction is not clear, or it can be somewhat inaccurate, because when you have jury instructions, I mean, it's a whole book of instructions that are supposed to be given to the jury so they know the law that applies to all the evidence that they just heard. And so, you know, both sides get a copy of what the proposed jury instructions are, and there's a lot of amendments that need to be made, you know, to be specifically tailored to the case. And so if you had a situation where you know, the rule on bribery covered two different types of conduct, and it didn't necessarily need to be that you prove both of them, but it could be either or. And again, I'm speaking somewhat in generalities and based on what you're telling me. Then, if either or of them was sufficient in and of themselves, that's why you would have the amendment. Because otherwise, if it were either or and it has the word and, then that would mean that you would need to prove both of them, which may not necessarily be what the law says. And so that's why you would have that type of change. So there's nothing in and of itself that is you know, that smells funny about a jury instruction or a verdict form being changed, even, you know, while the jury is deliberating. What would probably happen is, you know, perhaps the DA or the assistant U.S. attorneys were going through the form and realized, oh, this says and it should be or, brought it to the judge's attention, and then, you know, that gets litigated. So them and the defense would have to go back and forth. You know, they're saying, hey, we want to change it to or. The defense is saying, nah, it should remain and for, you know, whatever reason. And then the judge rule. If the judge ultimately was convinced that it should be or, then the modified verdict form is what they would get. So that's, hope I answered that question. So what was the second one?
The second one contains to him not facing his accuser. There was a Jane Doe 20. She did not come to the trial to speak on audio that was being played, and they allowed that audio into evidence.
Mm-hmm.
And she did not show up to so that he could face his accuser.
So what generally was on the audio?
It was supposed to have been an audio of him getting mad about her stealing from him, stealing a Rolex watch from him. And they say that
basically verbally abusing her.
Yeah, verbally abusing.
Okay. So there were portions of the tape in which he was saying things, but also there's audio of her saying things as well, or just him?
Both. But the thing is, they didn't play the whole tape to tell you exactly what reason why he originally was chastised, not
Going
talking
off.
to her, going off of her is
That was one of the allegations.
well, yeah, I mean, going off of her, but they didn't play the whole tape. They played snippets of the tape.
Okay. Yeah, but she never took the stand to speak on it.
Yeah, so in terms of a defendant in a criminal case, so actually let me back up a little bit. Out of court statements offered to prove the truth of what is being said is called hearsay, right? And so which basically means that you can't say, well, he told me that, he killed her. Well, actually, that's not a good example, because if it's in a statement by a defendant, those statements can come in, but the statement, an out of court statement, offered to prove the truth of what's being said, can't be offered. And so in this situation, if you have an audio recording and it has Robert Kelly saying things, then those are going to come in, because, again, an exception to the hearsay rule is, statements or admissions by the defendant. In terms of the female's statement, there would need to be another means through which those statements could come in, perhaps, probably to provide context. Because if you just have him talking by himself, then you don't have anything, you don't know who he's talking to, you don't have any response or anything like that. But in terms of whether she should have been called, if the defense wanted to call her as a witness for whatever reason, then they should have been able to subpoena her. And if she decided that she was not going to come in response to the subpoena, then then she could be arrested for failure to respond to a subpoena. But I don't know if you mean that the prosecution elected not to call her. I mean, they could call her if they wanted to. Obviously, they maybe didn't. But in terms of the defense calling her, if they wanted to call her, then they could have, to clarify or to allow her to be subject to cross-examination. But that's a different question from if they subpoenaed her and she decided she wasn't going to show up versus not subpoenaing her at all. I don't know.
Well, she claimed she had a panic. They claimed she had a panic attack, and that's why she couldn't testify.
Okay. So I mean, if there's a medical necessity, I mean, obviously the court's not going to force her to testify in that situation. I think if the person is that necessary of a witness to the defense, then a panic attack is only going to last so long. They could, right? I mean, then they can call her on another day, or the court can accommodate the schedule. Again, it's difficult. We're getting through this, right? If we're a team here and we're talking about this whole thing, we're getting through the issues. It's a challenge to know everything that's gone on in a particular trial. When you're talking to an active attorney, if they're worth their salt, they're going to be busy, and they're generally not going to have time to follow a whole trial unless they're not active anymore. But hey, I mean, in terms of being able to at least get through these issues and have some discussion, that's going on. And just like to make things clear, I really don't have a bias one way or the other. It probably sounds like I'm sitting here on the prosecution team. I'm not. I'm just a defense attorney. I'm a lawyer generally, and I understand the law, and I'm here to offer information. But in terms of, because there's a lot of people, hashtagging free R. Kelly, I don't necessarily feel that way, because I don't feel like I have a dog in the fight. Obviously, I can say, as a Black man, I don't like ever seeing someone go through the system, who's a person of color, a Black person, that goes to a bigger societal issue. But in terms of this situation, I just don't, I don't really have a dog in the fight. So I just wanted to be able to go through, the law and answer and address some of these issues to the extent that I can. So,
and and I do, Jamahl, I do appreciate you being very candid and just showing us both sides, because sometimes we do have to swallow that hard pill, because they end up getting a conviction, and we need to know why, how, and if we still walking around here with blinders on thinking, oh, they did this, obviously there's something that happened in the case where they were believable in terms of the verdict for the for the jury to come back with that, even
Right.
though to me, I was there and I saw the inconsistency, and I was like, if I was on that jury, there was no way anybody could persuade me to vote guilty. It would have been hung jury if I was on it. I know that for a fact, because what
Yeah.
I heard, and I don't understand how they bypassed the inconsistency, because that was one of the instructions. She said, if you find that the testimony of this particular witness doesn't match and is inconsistent, that means it's not guilty. And that's what I would have had. But
Well, to clarify on that instruction, I really, really, really appreciate more than you can understand your, despite the fact that you are a fan and a supporter of this man, your ability to be objective and listen to information and be so graceful about that is definitely something to be admired. So props to you for that. But when it comes to inconsistencies in testimony and or lies, there's a jury instruction that says if you believe that a person is lying about a particular issue, then you can discard their testimony in its entirety. All right. And so on cross-examination, as a defense, you are doing everything that you can to put that person's credibility in question. And there's an art to it, right? So you and some defense attorneys are just really bad about it in terms of trying to create issues that don't exist, or trying to make people who actually are credible out to look not credible. And that can really blow up in your face, especially if you're just trying to do too much in order to like impress your client or what have you. And so you got to be careful about that. But my point is, and this is what I was saying earlier, a person can be untruthful about a particular issue. They can be inconsistent about a particular issue and be telling the truth about something else. So, and again, they may not be a person that the jury likes. They may have done a lot of things that the jury doesn't like, but if they ultimately believe that what they're saying at the end of the day is credible and believable, then they're going to vote how they vote. And so going back to this issue where mom had initiated discussion saying that that her daughter was 18, and the daughter going along and saying she was 18 and telling police she was 18, that in and of itself, I mean, those are things that are obviously going to raise up some flags in terms of, okay, so we got some issues to pull up on cross-examination. But again, if she ultimately, despite all of that, all of those issues, which again, between the mom's conduct and her conduct, lying, I don't believe it ended up going in front of the jury why she said she lied initially, which it sounds like because she knew he had that other case, and so she didn't want to she knew that he would probably not want to engage if she came out the gate saying she was 17. All this is very deceptive, but ultimately there was the testimony in which she said at a certain point, I said I was 17, and so he continued to have sex with me when he knew at that point that I wasn't 18, that I was 17. And so me just, looking at that testimony objectively, if I'm the defense, I'm like, man, that's a problem. That's a problem because, I know that I'm gonna be able to cross-examine her on, what her mom did, what she lied about, but I know that there's a problem, and this is a conversation I'd have, if Robert Kelly was my client, I'd have to be open and honest with him to let him know, like, listen, yeah, I'm going to be able to attack her on cross for lying initially. I'm going to be able to attack her on cross for what her mom said initially. But when she says that, at some point when she was 17, she said that she told you that she was 17 and you had sex with her anyway, that's going to be a challenge. I mean, we're in a difficult spot. So we're going to have to come up with something else. And these are the type of conversations that lead to a decision whether you take a deal or not, right? And I don't know what the offer was in this particular case, if there was even an offer, but when and I hate hearing and especially when it comes to my young Black brothers and sisters, when I hear that they had an attorney and that attorney either forced them to take a deal or they pled guilty to something that they weren't actually guilty of, or they didn't do to the extent with which they were charged. And when that happens, when I hear that happens, that lets me know if it's true, because some people lie. I mean, some people just don't want to take responsibility for their actions. But when that does happen and it's true, it's because that attorney didn't take the time a lot of times to go through the evidence with their client. And because, there sometimes you have clients, again, who don't want to take responsibility for their actions and want to blame any and everybody else for the situation. And they would need to see, hey, this is the evidence against you. Let me know, what the truth is, and we'll, ride with whatever defense that you have. And so you'll go through that information with them, such that in the end, if it is their decision to plead guilty, if they decide to take a deal, then they know that that was the best situation for them. Because if they would have gone to trial, it wasn't going to go good for them. But I've also had situations where it's a bad case, and what I mean by bad case is that the government's going to be able to prove their case beyond a reasonable doubt. But you tell your client and you say, hey, well, we can take this deal, or we can make the government work for it. And sometimes the trial is just to make the government work for it. That is their obligation. It's their burden. The government and all its resources, because it wasn't always this way. There was a time when the government could just say, okay, you did this, and there was no jury, there was no trial process, none of that. If the government said you were guilty of committing a crime, then that was that, and then you were punished for it. But now, we have the presumption of innocence. People are innocent until they're proven guilty. You have the right to a jury trial, to have 12 members of society hear the evidence against you and make a decision as to whether you're guilty or not. And so I know I'm kind of going on about this, but this is an issue that really affects our community directly. And so this could be a cautionary tale for either someone or their family member. If you are in a situation where you're being charged with a crime, and you have an attorney, because everyone has a right to an attorney, whether that's private counsel, which I'm a private defense attorney, or if you have government counsel, you have a right to see that evidence and have the attorney walk through that evidence with you and make sure that there are that each one of your potential defenses are being properly considered, evaluated, analyzed in order to really assess and make a decision as to whether a deal should be taken, or you should take the case to trial. Because you get to trial when you have two sides that aren't able to agree on how the case should resolve, and that's how you get there. But in this case, there may or may not have been an offer from the United States in terms of, all right, if you plead guilty to XYZ charge, and this will be the range of your potential sentence. And then going from there, obviously either no offer was ever made, or they made an offer and that offer was rejected by the defense and they decided to go to trial. And that's what we just had recently.
Okay, I do have a question in regards to that. Now, you said that the attorney should go each line and going over with the defendant. Now, if they did not have the opportunity to do this, would that be a reason for ineffective counsel, for appeal process, or how does that work into play if they didn't have that opportunity?
So I know that there was an issue with attorneys coming in sort of later in the game, right? Because this case isn't new by any means. I mean, the indictment. The indictment that you had sent me, the superseding indictment, which means that there was a prior indictment, was filed in December of 2019. So this case has been going on for a while, So there would have been enough time for someone, whoever's on the defense team to go through the evidence and engage in that process. Whether they decided to do so or not is another question. The other issue is if you had, because I know this was asked to me over the phone, and then the prior attorney was asked, well, if you got this case, 2 months before trial, would you take the case? And my answer was absolutely not, unless I knew the judge would grant me a continuance to give me an opportunity to prepare. Again, I'm a practicing criminal defense attorney. I've got all kinds of cases pending. I got drug cases. I got an attempted murder pending. I got theft cases. I got assault cases. I got all kinds of stuff going on, such that if a case comes to my door and a person is, potentially facing either decades or life in prison, no matter what, I always got to make sure that I have sufficient time to be adequately prepared to represent somebody. Their liberty is on the line, and they have a right to, the best defense. And so, in that situation, again, if new lawyers are coming in on the case, then yeah, ideally you're going to want to make a request for a continuance to allow you sufficient time, because if you're not adequately prepared, then yes, that could be ineffective assistance of counsel. And so ineffective assistance of counsel is when the lawyer falls below the the reasonable standard of what could be expected out of a lawyer, and if falling below that standard then prejudices the defendant. So in other words, if things would have turned out differently, but for the lawyer's lack of preparation or lack of care or failure to do some particular thing or actually having done some particular thing, then yeah, that would be grounds for or that would be a something that could be argued on appeal. But again, yeah, in terms of me jumping on a case, again, unless I had that that sufficient time, then that's not something I could personally do.
Thank you. Now I'm going to bring in Stats. Stats, come on in, ask your question.
Hi, good morning. So I just have a
Morning.
question. Thank you so much for coming in today to help
Of
us out
course.
to understand the situation a little better. So I was wondering if there's any way that there could be a habeas corpus to help him, or how, I understand it is for 1 year that they have to do that. So can you explain that?
So, so I know that the prior attorney had spoken about appellate issues and habeas corpus. To be honest with you, that's not really something. I'm not an appellate attorney. Generally speaking, I carry my cases through verdict, and then once a verdict is reached, then that would be for the next attorney to handle. So, anything outside of perhaps a motion for a new trial or anything like that, that would basically be where my duties end. So I know that generally speaking, when you're talking about habeas corpus, you're talking about somebody who's basically illegally being detained, or their rights, their constitutional rights are being violated. In this context, I imagine it would be, based on his continued detention.
Mhm.
But outside of that, I can't really necessarily say whether habeas corpus becomes an issue, apart from the appeal process, which will certainly come into play, after the conviction. So he'll have his chance to file an appeal. Whether there's any particular grounds for habeas corpus, I'm not certain.
All right. Well, thank you.
Okay, now we're going to go back to Dottie. And let me know when it's too much for you.
Me?
Yeah.
Oh, I think we can go. We'll just see where we go.
Okay.
If questions start to tail down, then we can close out. But
Okay.
I can
all right.
answer for a little while longer.
Okay, Dottie.
Well,
go ahead.
actually, I'm sorry. No, actually, Sylvia, my question was already answered. I just wanted to know, with the magnitude of this case and attorneys coming in 2-3 weeks prior to the trial, the start date, how easy or hard would it have been for them to actually win this case? You answered that.
So I don't know that it was 2 or 3 weeks before. I mean, what was it actually? Because I mean, that would just be pretty much malpractice to jump in on a case like this 2 or 3
Yeah,
weeks
trial
prior. But it
started.
was.
It
Go
was
ahead.
originally supposed to start August the 9th, but the judge gave him an extra, I think like 9 days. But he was assigned, or he came on as a attorney July 15th.
Okay, so that's how long? They like 2 months or so.
No, July and August. August it
Oh,
started.
oh, then I mean,
Yeah,
he
it was
had
less than a
another.
month. It was 3 weeks.
Okay, so there were other attorneys that were already on the case, right?
Yeah,
Correct.
there was
Yes.
2 other attorneys that was on the case that had the 3500 material, but the 2 new ones did not have it at the time when
Okay,
they came in.
so I mean, you have a right to a defense, right? You have a right to the counsel of your choosing, but to bring on, a lawyer 2 or 3 weeks before your trial, you a judge could give you more time, but they don't have to, and it wouldn't be out of line for the judge to deny the request for a continuance because the trial date doesn't get set a month before trial. I mean, the trial, especially, one like this, is going to have been set, perhaps a year beforehand or so, like that. So, you need to have your defense attorney lined up and ready to go by that date set. You need to operate under the understanding that this is a trial date. And so if you decide, I'm going to bring on a lawyer 2 or 3 weeks before trial, then that's just not wise. That's borderline foolish to bring in an attorney that late in the game. And I don't understand, how a person could, I don't want to go too far with that, but I don't understand how an attorney would decide with a case of this magnitude. Yeah, I'm gonna jump in 2 or 3 weeks before trial with not having, if that's the first that they're seeing this file, that's really that's risky. I'll just leave it at that. Very risky.
Okay.
So,
Daddy Lolo?
Oh,
just
sorry.
from
Just
my
and to answer that question, with the volume of evidence, she was asking me, do I think that amount of time would be enough, to win? I'll take it out of the conversation of win, lose, because and if you guys like, I can talk about why it's not necessarily a good thing to say, win and lose in the context of a criminal trial, but
Please
I
explain that too.
okay, I'll explain that
Thank
after. Okay, so then it would not be enough time to sufficiently prepare for a trial of this magnitude. 2 or 3 weeks would absolutely not be enough time. With that being said, the win and loss thing, because that's a question I get a lot, especially when people are shopping for an attorney and they'll ask, well, what's your win and loss rate, right? As a very common question. And we measure a lot of things in terms of wins and losses. You have the NBA and the NFL, and you either have a winning record or you have a losing record. You went 8-8, or you went 14-2, or whatever your schedule was. But in terms of being a defense attorney, wins and losses, I don't exactly like using, and the reason why is this: there aren't defense attorneys, despite what you hear in rap lyrics and all that kind of stuff, where you're just throwing them a stack of money and they're just beating cases. Like, the reality is, on the defense side of things, when you're a criminal defense attorney, a lot of times your clients will have done something in the nature or in the realm of what they're being charged with. All right. So yes, there are your situations, and the darker your skin is, the more it seems it's likely to happen, where people are innocent and they're getting accused of and or even convicted of crimes. That does happen. But generally speaking, we don't just have jails and prisons full of a bunch of people who didn't do anything whatsoever in terms of what they were being charged with. All right. So if we just take that, because backing up even more, law enforcement agencies investigate, alleged criminal activity. They take their reports, they take their evidence, and they turn it over to the DA's office. Or if we're talking about the federal case, we're talking about the U.S. Attorney's Office. These prosecutorial agencies get thousands of cases that never see a courtroom at all. They get rejected because that prosecutor who is tasked with going through the evidence is looking and seeing if there's something that they can prove beyond a reasonable doubt. And if they don't believe that they can, then the case, just doesn't get charged. So there's a lot of, people who end up, not actually getting charged, even though they were either arrested or under investigation, what have you. With that said, other cases that do, ultimately get charged, listen, and to get to the point, if I have a client who is facing, let's say, 10 years in prison, right? And we go through the evidence. So like I said, and this is something that, based on my conversations with some other attorneys and everything, is not exactly common. I wish it was. But when we go through all the evidence, and ultimately, if my client did what they're alleged to have done, but it's just not as egregious as the prosecution is making it out to be, or it's not to the extent that they're making it out to be, if I can get my client a deal where he's doing, half the time he would otherwise have to do, then that to me would be a quote unquote win. Because if, but it's not if you say either conviction, no conviction. If you look at it as win or loss, win or lose in that sense, then everything, almost everything where a client is convicted would be a loss. Versus, I had a situation, to provide a more concrete example. My client was accused of a drug trafficking offense, so possession for sale of cocaine, and all of this is public record. I'm not violating attorney-client privilege. There were text messages that established drug sales between my client and, his different customers, what have you. So, and when the police, entered his home and searched, they found cocaine. So they found cocaine. There might have been a little bit of cash, what have you. So they charged him. And so in that situation, he absolutely did what he was alleged to have done. All right. And the deal that was presented to him was for 5 years in prison. So if he signed the change of plea form, he would have, done a 5-year prison sentence. He was represented by an attorney, right? And felt like, the attorney wasn't doing everything that he should be doing or what could be done. So he ends up reaching out to me, and I'm pretty hesitant to take on cases from other attorneys. I really like to have a case from the beginning because, I have my own style, I have my way of doing things. But in limited situations, I will take over cases from other attorneys. And so I took over this case, and ultimately, yes, my client did what he was alleged to have done, and that was pretty clear. But from my perspective, the way I see things, there's always a story behind everything. Everybody has a story. Everybody has a reason why they do what they do. And oftentimes digging into that story can be what would ultimately make a difference in being able to get a particular result. So we go through, because I see, this is a good kid. I say kid, he was like 23, 24. Good kid, worked hard in school, had a good job, was in a long-term relationship, was about to have a kid soon, all these good things about him. There was information about his family history that we went into. And so we end up interviewing him. Me and my team interview him. The interview takes a few hours. We put together a whole packet of information saying how this was an isolated incident. This won't happen again. These are the reasons why. This is what he has going on in the future, and how much his life would be derailed by having to go to prison, and how much you might end up, just permanently injuring this person if they have to go to prison. Now, again, the offer on the table from the DA was for 5 years, and he was, essentially prepared to sign that deal because the DA or because he knew he had done what he was alleged to have done. Ultimately, we were able to negotiate a deal where, yeah, he had to plead guilty. He signed a deal, but he didn't do not one day in custody, not one day. And so if you, again, that illustrates the point that if you say, okay, if the person is convicted, that's a loss. If the person is not convicted or walks or is acquitted, then that's a win. Then you'd be saying that that's not a win because he was convicted. But in a situation where he was offered a deal, which there wouldn't necessarily have been anything wrong with that deal. I mean, it wasn't an offensive deal, but at the same time, the prosecution didn't have the full story. And that's where there's no substitution for a defense attorney spending time with their client and doing their necessary investigation and getting all sides of a situation in order to put your client in the best possible position for a favorable outcome. And so I describe those type of situations. Even for me, if I take a case to trial, so I had mentioned I've represented people accused of murder. Some attorneys have been practicing 30, 40 years and have never represented somebody facing murder charges. I've represented 2 people at trial facing murder, and I've had a number of attempted murder cases. With that being said, in the first one, my client was ultimately found guilty of second-degree murder, right? And so that carried a 15-year to life sentence in the state of California. The DA was very adamant about it being a first-degree murder. So the difference, at least in California, between first-degree and second-degree is whether it was premeditated or not. And our position was that, hey, this thing happened out of nowhere. Yes, and there was a complete concession. Yes, my client killed this other person, the alleged victim. My client did kill them, but this was not premeditated. And the DA is like, it's premeditated. And we're like, no, it's not. And ultimately, if he were found guilty of first-degree murder, then that would be 25 to life. And ultimately, the jury came back with second degree. They found him not guilty on first degree. So in that situation, yes, I mean, he's still, he was sentenced to 15 years to life. And so, but the difference between, say 15 years and 25 years for us, because we were already conceding again. So we weren't arguing that the killing never took place. We weren't arguing, obviously you had a dead body. We weren't arguing that it wasn't our client that did it. We were just saying, hey, this was not premeditated. And so for us, if you look at that and you say, okay, well, this man was convicted and sentenced to 15 years to life, no one perhaps would look at that as a win. However, we did, and he understood because, the DA was going after him for, and quite aggressively for first degree and 25 to life. So I hope that somewhat illustrates, why it can be, just inaccurate, and no, nothing against you or anybody else who says that, but just saying, quote unquote, win and loss it isn't really in a fair representation of what is done on the defense side of things. The other thing is they're just being victory in the fight, right? And I know like nobody wants to get convicted of anything, let alone have to go to jail or have to go to prison. But sometimes sometimes you're in a case where again there are people who commit crimes, right? And again, we can get in, or we're not going to get to the broader societal issue of certain people being in certain areas and due to lack of resources and lack of solid economic position, why people might end up committing crimes. Let's just say generally there are people who commit crimes, and sometimes the evidence is strong against those people who commit the crime. And so where I'm going with this victory being in the fight, sometimes the victory is just making sure that the person was treated fairly within the system and their constitutional rights were protected. And so in that situation, even if I have a client who, ultimately is found guilty, whether he pleads guilty or goes to trial and is found guilty, if we did everything that we could, we did our proper investigation. We did our legal research. We put together all the, defense theories we could come up with, but ultimately the result was what it was. Then to me, I mean, that has to be a victory, because if not, then I'm just, wasting my time doing this, or I'm doing people dirty by not, and that's why you can't necessarily base, like, I can't say, okay, well, I'll base me doing a great job by whether the client ultimately gets convicted or not, because that is just a common occurrence. Actually, it's more than a common occurrence. There's, a very high conviction rate, whether it's state or federal. So that is just a redefining of, what is a quote unquote win or loss. And for a lot of people, that's the first time they heard it broken down in that way. So, hopefully that was somewhat instructive. I see a question in the
Thank
chat
you.
saying, what about the scale being equal to present a fair case?
Yeah. And I was going to give you another question on that.
Okay.
That side too. Someone said, after you do that one, explain how stipulation works after you answer the first one.
So what about the scale being equal?
Yeah.
So I would need a bit more to answer that, just, what they're talking about specifically, because
I think it's more black law, white law, because you can have two people with the same charges, one being black and one being white, and it seems more leniency is towards the white person than the black person. They throw the book at them.
Yeah, and that's just a bigger societal issue that is probably the beyond the scope of this discussion. But I am certainly aware of these issues and sensitive to those issues. That was in part my motivation for going to law school. When I was in college, I was an Africana Studies minor, and so I took history from a Black perspective, Black psychology, Blacks in the justice system, and really it was Blacks in the justice system where I learned how in so many ways the laws were bent, manipulated to continue to exploit and oppress Black people. So I'm certainly aware of those issues, and that is more something for the policy man to address, in terms of just broadly speaking for the nation. But, we as defense attorneys, in our one-on-one clients in cases, all we can do is make sure that, that we're presenting the best defense possible for our clients and fighting as hard as we can individually and therefore collectively for our clients. So, if I see a situation where, perhaps a judge would or a DA would lean a certain way, if I knew that, my client was white, then I would make sure that same, pass or leniency would otherwise be presented, because if you think about it, that situation that I was just talking about, where we were able to ultimately negotiate that deal where my client didn't do any time, even though like he was essentially prepared to sign up for a 5-year deal. He was Black, he's a Black client, and so it was a situation where, again, this is unfortunately, if we just look generally in terms of who typically will have resources to hire an attorney, in that situation, there has been a traditional lack of access to counsel in that situation when we're talking about, Black and brown communities. But in that way that defense was presented, it really wouldn't have mattered whether he was Black or white or whomever, and the fact that he was Black is very telling of, what my point is in that when a defense attorney ensures and does everything that he can to make sure that his client is treated fairly within the system and protects their constitutional rights and really has their best interests at heart, then in that one-on-one situation, there's a lot that really can be done. It's just that we hear about all these situations, you know, the ones that make the news headlines and the most egregious examples. And it can seem that, you know, your client can't necessarily get a fair trial. But again, I think that's, you know, a much more macro societal question, but hopefully hopefully that response at least touched on it. But the next question in terms of a stipulation is just a fancy word for an agreement. So in order to, you know, in the interest of efficiency, so judges, you know, really like to keep cases moving, keep trials moving. They don't want to, you know, overburden or overwhelm or bore the jury any more than they need to. So there are times in which the defense and the prosecution both agree on a particular fact, and so they can enter into a stipulation that a certain fact is true or that a document is what it says it is. You know, for example, you know, perhaps we would stipulate that this is a bottle of hand sanitizer. So we wouldn't have to have an expert come in and testify that, you know, this is water and alcohol and aloe and glycol, and I tested it to make sure, and I came to the conclusion, you know, that it was hand sanitizer. That testimony, you know, between the witness testifying as to their education and their qualifications and their experience and all this kind of stuff, just to reach the conclusion that they tested this and this is hand sanitizer, we can avoid that by entering in a stipulation that it is in fact hand sanitizer. It's a good example.
I think Janice is here. Janice, did you want to ask a question? Okay.
Oh, okay. I'm here. I guess I must have stated it wrong. Can you hear me?
Yeah, we can hear you.
Okay. I was trying to talk about the scale, how they say the prosecution and the defense is supposed to bring the evidence into the judge, and then how the judge was going so more towards the prosecution side and throwing out everything of the defense. So the scale was not even for them to be able to, you know what I'm saying? They didn't have a fair play because the scale was leaning towards the prosecution side because they had so many things that she allowed in and not enough that the defense had allowed in to be able to even work with.
So first of all, you know,
you're breaking up now. Jamahl, you're breaking up.
I haven't done anything differently. So
now I hear you back. I hear you again. You good now.
Okay. So in a trial, the prosecution and the defense are not on an equal playing field in that the defense doesn't have to prove anything at all. The prosecution has to prove their case beyond a reasonable doubt. So realistically, the defense could not say a word. They could sit with their arms crossed the whole trial because they don't have, you know, they don't have whatsoever.
You bubbly.
You're breaking up again. You're breaking up again. Seems like your connection is kind of choppy now.
I know, maybe because I unmuted myself. I'll go back and unmute.
I don't think it's you.
Okay. So
still choppy.
I'm just gonna.
You might have to hang your hand outside the window. I'm only kidding.
Let me see. Yeah, because I mean I've been sitting here and
you were great before. I think it's the daytime traffic of the internet.
Possibly. I don't know if I switch, because I have another network in here. If I switch it, will it completely drop?
If not, if it does, you can just click the link and come back in.
I can hear him now.
Now you're good. You're good now. You're good.
I unmuted myself and it seemed like he got clearer.
You're good.
Okay.
Maybe it's my antenna.
No, it's not you.
All right. So, so the prosecution and the defense going into a trial, you know, are not on equal ground legally. We can talk about, you know, perception of a person accused of a crime and all of that, but let's just say legally, because the defense has no burden whatsoever, the prosecution has the burden of proof. And so, and the defense has the presumption of innocence. And that's, something else that you really get into in jury selection. You understand that you're going to be hearing a number of charges and you're going to be hearing a number of witnesses. But unless and until the prosecution ultimately proves the defendant guilty, are you okay with following the law that he is presumed innocent? He has the presumption of innocence. And so given that presumption of innocence and given the burden that the prosecution has, they're not on equal footing. All right. So that's number one. Number two, in terms of the evidence that the prosecution is able to put forth and the defense not being able to put forth certain information, again, the prosecution having the burden of proof, they have to prove their case, right? So, with this indictment and the number of allegations, especially when we're talking about, the enterprise, they can't just say, well, he had an enterprise. No, they have to actually put on people who can testify what their roles were in this particular enterprise. So that took some time, and we have multiple alleged victims in this case, so they all have to testify. So there's a great volume of evidence that they were going to put on, and so it was just naturally going to be lopsided in terms of the information, because it's not like the defense side was going to put on evidence that it wasn't an enterprise. They weren't going to put on, there was a lot of stuff that wasn't going to necessarily have an equivalent on the defense side. And so, but in terms of the admissibility of what would come in, primarily evidence has to be relevant, right? So it has to be relevant, and it has to be admissible under other issues as well. And so if the defense wanted to present certain information, and it would be otherwise like favorable for the jury to hear this information, but it was legally just not admissible, then that's where you're going to have the exclusion of information. And when you have what are called motions in limine, that's when the defense and the prosecution will, they'll put together their motions in terms of the evidence that they want to have go in front of the jury, and then they argue, back and forth. Sometimes there's no argument, and we'll stipulate to the admissibility of this particular piece of evidence, or there may be a fight about it, and if there's a fight, then the judge ultimately has to rule on whether that evidence is coming in or not. And so, just generally speaking, in all criminal trials, you're generally going to have an imbalance in terms of the volume of information that the prosecution is putting forth versus the volume of information that the defense is putting forth, just by virtue of the burden that the prosecution has. So there, you can have a lot of criminal cases in which the defense doesn't really call any witnesses at all. They're just cross-examining the prosecution's witness. So in almost all criminal cases, there is going to be that imbalance in terms of what the volume, the respective volumes of information that's being presented. But again, if the defense wants to put on a case and they're well within their right to do so, the evidence that they want to put forth has to be relevant and otherwise admissible. If it's not, then it's not going to get in front of the jury.
Thank you so much for that. Was that the whole stipulation? Remember, I asked you to walk us through the whole stipulation, how a stipulation works. And
yeah, I mean that's it. I mean, like I said, a stipulation is just an agreement about something.
They had like 25. They had 25 stipulation in this case.
Yeah.
So
those are 25 agreements to not waste the jury's time with testimony. I mean, there can be stipulations for different things.
But they were for inconsistencies. That's what I heard them saying, the stipulation for inconsistency.
Well,
I don't know the details of it, but that's what it
Yeah.
was talked about.
But again, I mean, if you just use the definition as your guide, that's what a stipulation is. It's the defense and the prosecution agreeing as to something. So we can stipulate to continue a trial date, right? So if I talked to the prosecutor the other day on a case. I'm supposed to be in trial now on a attempted murder, but we stipulated to continue the trial date for a number of reasons. But so that's an agreement versus me making the request and the DA or the prosecution is opposing it. So again, if you have in the context of trial, we're talking about stipulations. A lot of times it's about a document being what you say it is, or about a certain fact being a fact without needing to have a person testify to it and be subject to cross-examination. We're just saying that it is, what we say it is. So, yeah, I mean, if you have questions about, a specific stipulation, I'm happy to answer that. But just generally speaking,
yeah, because I don't know what the stipulation was actually, because they didn't show it to us, so I can't really talk on it. I just know they said something about inconsistency, and then there was, I think, 24, and then they added 2 more, something like that. So I don't know the details.
Well, if we're talking about inconsistencies,
of the witnesses,
it might have been for the purpose of allowing someone to testify to something that otherwise would be hearsay. So again, an out of court statement offered for the truth of the matter asserted would be hearsay. So generally speaking, you can't have out of court statements brought into court and testified as saying that it's true. You have to have witnesses come in and testify as to what they experienced or what they saw, what they perceived, what have you. But as an exception to the hearsay rule is a prior consistent statement or a prior inconsistent statement. And so if you're stipulating that, okay, yes, this was an inconsistency, and so therefore we'll allow this person to testify as to what would otherwise be hearsay, but because it's a prior inconsistent statement, we'll allow it. I mean, I'm stretching, but that's the, if we're talking about stipulating as to inconsistencies, that's really the only thing that comes to mind as to why you would have that.
Okay. Another question, sidebars. There were quite a few amount of sidebars in this case.
Yeah.
Does that work against the defense, against the prosecution? I mean, some people, because I was doing a couple of research, and they said sometimes it's done to diffuse some of the defense. It's like a tactic that's used. So can you elaborate a little bit on that?
That's a good question. So the purpose of the sidebar is to not have the jury hear things that they don't need to hear or should not hear. And so if you, and obviously, I mean, again, I haven't seen all the transcripts, but from what I was seeing, it didn't look like there was just an excessive number of sidebars. In any trial, a lot of times you are going to have sidebars. And again, it's just allowing the judge or allowing the lawyers to discuss certain things with the judge, or sometimes the judge will call the lawyers over at sidebar to discuss things that should not happen in front of the jury. So I specifically in this case, there was the issue in terms of why one of the Jane Does, I think it was Jane Doe number 5, why she said she was 18. And so they were arguing, and this didn't happen in front of the jury, and it should not have. They were arguing as to what the jury should hear in terms of why she said she was 18. And so it appears that the real reason was because she knew that that he had a sexual exploitation of a child case or some sort of sex with a minor case. And so the prosecution, they wanted the jury to hear as close to that as possible. The defense just wanted it to be, just generally a trial or some sort of court proceeding, because obviously they didn't want the stain of, that prior case to be, heard by the jury. And ultimately, the judge did not allow that information to be heard by the jury. And so you don't want to have the jury privy to, what's being discussed. And a lot of times jurors, they want to know, well, why are they hiding stuff from us? And that's to keep things fair. And so I would say, just in terms of whether sidebars are beneficial to one side or the other, more so, I would say that's not the case. It's just, again, it's to make sure that the jury isn't hearing things that, they don't have any business hearing, because it would otherwise, prejudice either the prosecution or the defense. So that's all that is when you have, or sometimes when you, a judge, when they hear testimony going down a certain road and they know that, if it continues any further, the witness might say something that is going to be inadmissible. And once a witness says something, you can't unring the bell, right? So so the judge will stop that before it goes too far, and then they'll sort out the legal issue. All right, where are you going with this, counsel? All right, well, I want to prove X, Y, and Z. Defense or the prosecution has a chance to say, well, no, they can't do that because of this legal reason, and then they'll argue it out, and then the judge will either allow them to continue on, or you saw in the transcripts a lot of times they say, all right, we'll just move on. I'm not going to allow you to go down this road.
But
Right?
Jamahl, it seemed that the judge was more towards the prosecution side. Because if you count the amount of overrules he had and sustain, it seems like the prosecution got a lot of sustain, and then the defense was, every time defense kept saying objection, they said overrule. It's like,
Well, a lot of, and to answer that question, I mean, a lot of questions that he was objecting to, just weren't legitimate objections. And so one thing that happens is when you're hearing testimony that is damaging to your case, it is a natural thing to want to avoid that answer coming out. But just because something is harmful to your case, and I'm not saying, I'm not attacking the defense. I'm just saying in general, because DAs and U.S. attorneys do it and defense attorneys do it too. It's just a natural thing to sometimes object to a question that's going to elicit testimony that's going to be harmful to your case. And there were a lot of objections made that, there was no issue of admissibility. The testimony was admissible, and so it came in. So I can't, based on at least the transcripts I saw, 800 or so pages of testimony, I didn't really see any objections that I saw that were either sustained or overruled that I just felt like was an abuse of conduct by the judge. And again, the volume of objections doesn't necessarily, it's not really indicative of something. I personally, I don't really object to a lot of stuff. I only object if I need to. And the reason is I just, when you object a lot and you're getting overruled, I think the jury can sometimes, now we're getting deep into the weeds of trial tactics and stuff. But, the less I can have the judge seeming like they're ruling against me or not on my side, the better. And so if I'm objecting to stuff and I'm getting overruled on my objections, that just doesn't look good. And so
are you saying that when you're getting objected a lot, it's telling the jurors, hey, the judge is, well, tell me, give me that little, because I don't understand. Explain to me what is the lingo behind that,
Okay, so an objection is you signaling to the judge that the lawyer has made a question that is either going to elicit a response that is inadmissible, or the manner in which they pose the question is improper. So there were some instances in which the prosecutor was, quote unquote, leading the witness. And so what leading the witness is, if I say, and so what happened next? And then the witness says, well, then I walked down the hallway and I heard a gunshot. So I've asked an open-ended question, right? If it's my witness, I can only ask open-ended questions. I can't lead the witness. I can't suggest the answer. As opposed to on cross-examination, I can ask leading questions. And in fact, you should ask leading questions. So again, if I say, and what happened next? And the witness says, I walked down the hallway and I heard a gunshot. As opposed to if I say, well, isn't it true that you walked down the hallway, correct? Well, yes, I did. And you heard a gunshot next, didn't you? Yes. So that's leading. So the defense was saying that the prosecution was leading a couple times. And what the judge said was that, hey, I get it. If she gets into a position where she's leading on, certain vital or crucial issues, then I'll stop it. But sometimes you have to lead a witness, because if you don't, they're going to be all over the place and adding a bunch of details and information that, is just going to overwhelm and overburden the jury, and is just not necessary. So it's not some crucial element issue. And so therefore they'll allow some leading of a witness. And so that is one of the issues that came up. But my point was just from a jury seeing me and me wanting to instill trust in the jury, and me wanting to instill confidence in the jury, and me wanting to instill credibility with the jury. That's why I don't object to a bunch of stuff that I know is going to come in anyway, even if it's harmful, to my client, because evidence being harmful doesn't mean it's inadmissible. All right. And so that's the issue. There's a difference between, and so, but to clarify that a bit, there's a rule called, relevance. So something has to be relevant, but there's also a next level of relevance that has to do with evidence that can be considered unduly prejudicial. All right. So if evidence is unduly prejudicial, then they're not going to allow that to be stated. So, in that situation, going back to the example that I was mentioning in terms of the reasoning why the Jane Doe said she was 18, it may be true. And, it may be true that the reason why she said she was 18 was because she knew Kelly had a prior criminal proceeding, and it had to do with sexual situations with minors. Even if that's true, that's just going to be unduly prejudicial to the defense, because it's not really relevant in to the ultimate issue in this particular case. So the judge wasn't going to allow any evidence about another case involving exploitation of minors, because that would be unduly prejudicial, even if it is true. So that's where you would have an objection. But for me, if I have I know evidence is coming, and I know that it's going to be harmful to my defense, but it's not necessarily inadmissible, then I'm not going to object just to object, because once I get overruled a whole bunch of times, and the jury's going to be like, well, what is he trying to hide? Or what is he, does he know what he's doing? Like that's the two things that would stand out to me. Either this lawyer doesn't know what he's doing, because he keeps on trying to have the judge stop stuff from coming in, and the judge is telling him no. So he either doesn't know what he's doing, or he's trying to cover up something, neither of which is good for me or my client. So that's, objection. Trial is an art. Objecting and when to do it and how to do it, under what circumstances is all of which are art in and of themselves. So
Okay. We
life
have
of a
Dottie.
trial lawyer.
Dottie has a question for you.
Mhm.
So, I mean, I don't know how much you've read as far as the transcripts or how much you actually know about the case.
Mm.
But do you think that there's grounds for the judge to actually overturn some or all of the verdicts?
From what I read, and I admittedly have not
I didn't give them
read
all.
of the trial.
I didn't give them all, y'all. I didn't give them all.
I read
Let's
about
just say some Jane Doe number 5.
what's that? What was the
Jane
question?
Doe number 5.
Yes,
I said, well, if
did
you
read
base it on
her
Jane Doe
testimony.
number 5, do you think that's grounds for it to be overturned?
To be overturned, I didn't see anything. There wasn't really anything that stood out to me in terms of because when we're talking about being overturned, there has to have been either some miscarriage of justice or some sort of manner in which the judge abused their discretion so significantly as to essentially constitute a violation of Mr. Kelly's rights, such that that particular verdict should be overturned. And I personally didn't see anything that that would rise to that level. Again,
So give us an example of what would be
judge-
considered a misconduct.
Because the judge had even said in open court that there was a lot of inconsistencies in her testimony.
And impeachment. And she
Yeah.
talked about the impeachments too.
Yeah, so a person being inconsistent doesn't mean that and we talked about this before. A person can have lied about certain things. A person can have been inconsistent about certain things, but that doesn't necessarily undo everything that they testified to. Let's just say, for example, the pastor that testified, right? So we had the pastor take the stand, and he had said that at a certain point he was working in, I think, some sort of real estate office, and at some point Robert had come through to his office and was inquiring about a pastor. He needed a minister in order to marry him and Aaliyah, and so obviously all due respect to her and her family, and rest in peace. But he said that Robert came by, asked about a minister. He made a recommendation, and it was his understanding that that person was in fact contacted, and that led to the actual marriage. And so he on direct examination, he admitted that he had been convicted of bank fraud and perjury. And so bank fraud, he had, conducted some sort of illegal transaction in which he was benefiting from a transaction that he should not have. And then perjury, where, perjury is when you knowingly lie, either on the stand or, in filling out a particular document. And so he was convicted of conduct that was untruthful. Right. And he did time for it. He was sentenced to 24 months. He ended up doing 7 months in boot camp. But that goes to show that he is documented as having, lied about something at some point in his life. However, there really was no cross-examination on that issue. Why? Because yes, I mean, you could say if there was enough about him, lying about a particular thing, then the defense could try and have his whole testimony thrown out in its entirety. But they didn't do that because his testimony came off as credible. So they didn't really have anywhere to go with his testimony. Now, he didn't say anything, particularly groundbreaking. I think, it almost goes without saying that, there was a marriage between him and her, and I forget how old she was, like 14 or 15, and that happened. So there's not really much place to go. That I'm only saying that as a point that a person can have been convicted of lying about a particular issue, and just because they were lying on a particular occasion and even documented as having done so, and even having been convicted of doing so, doesn't necessarily mean that they're lying about something else, or it could mean that they're lying about something else. So that's something that you can exploit. Well, isn't it true that, you know, in this year you were convicted of bank fraud, weren't you? And you engaged in a illegal transaction, and, you know, that's dishonest. And then on top of that, you were convicted of perjury. So, you know, and in your closing argument, if you were trying to say that that person is a liar, you say, well, how can we believe anything this person says? I mean, this guy was convicted of bank fraud and perjury, but there's only so far you can go with that, because at the end of the day, you know, the jurors, I mean, you know, you have to be reasonable with your arguments, because you can't just necessarily try and say that because a person, you know, lied on a particular occasion, or they were inconsistent on a particular occasion, that, you know, that they're necessarily lying today. And again, you know, this is the witness that we have, that we're talking about, in terms of, you know, having said, yes, you know, I am 18, and sailing officers, I'm 18, and my parents said I'm 18, but at a certain point, then later on saying, no, actually I'm 17. And so you have to put all that, you know, aside, or you can either believe that they're being honest about having said that they were then 17 and then this stuff carried on, or you could believe that they're lying about that. But you would probably have to have some basis or some reason to believe that they were lying, or contradictory testimony, again, ideally would come from your client saying that, you know, this whole time, you know, I believe that she was 18 and she never told me that she was 17. You know, that never came out of her mouth. So I had no reason whatsoever to believe that she was 17 as opposed to 18, but we didn't get that testimony.
So because of a document that they did
she
for the
signed
schooling thing,
for affidavit.
I'm sorry, I'm getting two people.
Dottie, hold on. So the affidavit that they received from the parents that basically solidified that she was underage, because they had to give permission for them to get out of school. Then that's what you're basically saying.
That's not what I'm saying, but that adds to the I mean, it on some level adds to the position that there was knowledge that she wasn't 18, because there wouldn't have been any need for that document, you know, the guardianship, if she were 18 already. So yeah, I mean, that just kind of goes to the prosecution's point. I know that's not what you were getting at, but that supports the position that there was some sort of knowledge that she was not yet of age.
What I was asking was, there was an affidavit that she signed for the attorney stating that she had not slept with him while she was 17. The affidavit that Sylvia is referring to is after he found out that she was 17. He sent her back home, and then they signed the affidavit.
Right. Yeah, I think you know, there was testimony about a series of letters. And again, this would be something that the jury would have to parse through and decide who they believe is telling the truth or not. But there was testimony that you know, he had us write these letters, you know, saying all these things. You know, I don't recall all the details, but basically, you know, actually, there I have some notes. I'd have to find them. Let's see. Let me. But yeah, there were the letters that ultimately she said that she was told, you know, to write these letters, and that they were, you know, protection for him. And that was, you know, on the advice of his attorney, that he had said, you know, if you're ever, you know, messing around with girls again, that you need to have these letters written so that you can, you know, protect yourself. And so she said, yeah, I wrote these letters. This is my handwriting, but, you know, this stuff isn't true. And so you could say, yeah, that's inconsistent. But, you know, she had an explanation for it. And, you know, you know, so there's the one where she was saying that, you know, there was letters that he had us write saying that we stole money and watches from him, and that we had been molested by family members, and we had been abused and neglected by our families. But she said that the words weren't true. She said we had to write these letters every year, and that's what we did. So you know, that's, again, these are issues that cloud the issue and raise doubt as to whether he knew or not. But ultimately, the jury had to have been satisfied that what she was saying was true. That yes, she wrote these things. Yes, it was her handwriting, but that the information in the letters was not true. It was made up because that was something that he had them do. So they believe that.
The other thing I want to ask you,
Mhm.
since he was not charged
I was
with
asking more
marrying,
towards the fact that what she actually told the attorneys.
Dottie's thing must not hear you. Dottie, you. Okay. Go
And
ahead,
again,
Dottie.
I feel like it's necessary to say, I'm not a prosecutor up in here or anything like that. I'm getting these questions and I'm giving my interpretation on how the jury could have reached the decision that they
Gotcha.
reached. I don't have any
Because
basis
everybody
to
feels
say,
that the statements I'm seeing on these chats is like they feel that you're for the prosecution, but you're trying to get us to understand.
I don't know why. Like I'm
No,
literally
trying
a
to
defense attorney, right? Like
See,
I'm not a
he's
prosecutor.
trying
I'm
to
not a
get us to
DA.
understand how the
Yeah.
jury may have come to those conclusions. He's not the prosecution. He's not on the prosecution hand, but he's trying to get us to understand some of the logic behind this. So don't attack him, please.
I can't see that. Oh, okay. Well, let's see. I see some. Okay, his point of view seems to be as if we were listening to a prosecutor. There's a way to present facts of law without coming off as biased. I don't know what you're talking about. Like, what do you mean? Like, there's evidence, there's transcripts, which I went through. Like, that can't be the narrative anymore. Well, you haven't seen the transcripts. Like, I read the transcripts at this point, not all of them, but the ones that I'm talking about, I've read them. And so I'm approaching this as, okay, I'm looking at the law. I'm looking at what these issues are. I'm being asked questions. I'm giving you an answer. I don't think I'm leaning towards any one way because I don't have a dog in this fight, but
But I did ask you I asked you to give us the raw truth because a lot of us want to walk with blinders. We can't walk with blinders. That's how he ended up having a guilty verdict because we kept walking. Oh, this didn't happen. This didn't happen. This didn't.
Yeah.
We got to be realistic, people.
Right. And I see someone. I had private chat up. I didn't see all the comments. Now I can see all the comments. So someone said he's not charged with marrying Aaliyah. Jocelyn, thanks for your comment. No, he wasn't charged with marrying her, but he was charged with bribery, which had to do, with the marrying of her. So he was charged with, being involved with, using money to influence someone to provide an ID so that he could marry her. So that's just a charge. Does that sound biased? Do I sound biased? I'm just reading, I'm reading an indictment and I listened to the testimony, or I read the testimony that, that they were providing in support of that. I don't, I guess.
The other part, Joyson just asked the fact he doesn't believe there's a prosecutional misconduct. First of all, but Joyson, I didn't give him that part. I didn't give him the opening argument statement. I didn't give him the closing statement. I just gave him Jane Doe number 5 testimony. I apologize. I was just trying to get him something so he can have something to come to us to discuss. So And I can't give him that stuff. He can come back and talk about that. But right now, it's what
I mean. Here's the deal. Like at the same time, no, I'm not changing my answers. I cannot be swayed by just a chat. You know what I mean? At the end of the day, I got 800 so pages, right? And it took hours, hours that I spent going through this stuff. And so, I have what I have. And then just in terms of the indictment, it's clear to me, just, I'm a lawyer. I've been doing this a long time. I know how these read, and it seems relatively apparent and obvious to me what the government would have put together in terms of their evidence to put forth this case. And so, when you have, situations where you have, parents acting for financial gain and people, trying to become famous and all that kind of stuff, that all of that is going to muddy the issues in the case. But, at the end of the day, in terms of, you know, in terms of the allegations where we're talking about having sexual interactions or relations with minors, again, when we have Jane Doe number 5, and I don't have the testimony. Actually, I think you did give me the testimony on the other one. Let's see.
I think the main one I gave you was Jane Doe number 5, because that's the one I was really.
Yeah. Well, there was Stephanie, and it looked like she had met him when she saw him at 16, and then she met him like a year later, and they had sex when she was 17. So there were the two, right?
Well, Stephanie, there was in state of Chicago, state of Illinois, so it was legal in that one. That's why he wasn't charged with underage with her. But the other one, he was the one that was 16.
Yeah. So I mean, that's all, you know, that I have. I can only, you know, I mean, obviously, I mean, I've been talking for almost 3 hours. You can't just say like everything I'm saying is not accurate. I mean, I stand by what I'm saying. It's just, you know, sometimes it doesn't look good for people that you support, and that just, you know, I don't know what to say to that. That's like it for me. It's a little. I'm curious as to everybody who has hashtag free R. Kelly and all this kind of stuff. Like if they're really, you know, being objective about this whole thing. Like, you know, I again, like I said, I don't have daughters, but I would have a serious issue with, you know, with my nieces, you know, hanging around with a dude in his 20s or 30s or 40s. That's just me. But that doesn't mean that I have anything against him at all. I don't know him. I'm a fan of the music, but you know, I don't, this doesn't really do anything for me one way or the other. But you know, I'm not.
Here's the thing. To me, this is Sylvia speak on this one. I don't feel he got a fair trial. I don't feel he has a fair trial. Here's the reason why. Because you have people who have gotten financial gains off of this. They muted him. They put him as guilty before the trial even started. He was not even able to make an income. He was not able to get bond when other people who have done similar crimes and even worse crimes were able to get bond. And
they froze his bank account.
Yeah, they froze his bank. Everything was done to him before trial even started, and that's what I have a problem with. I really do have a problem with that.
Can I ask one question?
Go ahead.
I'm sorry, I don't mean to interrupt, but wouldn't it be okay with Jane Doe 5, with her parents saying he was 18, with her saying she was 18? Ain't that entrapment?
So entrapment is generally with law enforcement. With law enforcement coercing somebody to do something that they otherwise would not be inclined to do. So I mean, we didn't have law enforcement involved in this situation, so that's a good question, but I don't really see that as having been a thing. And again,
when the law enforcement be when they had checked her ID for.
Yeah, but the law enforcement didn't put him in the room with the girl. The law enforcement didn't set that up. All they did was, you know, talk to her, and she said, "I'm 18," and they, you know, checked her ID, and ultimately were like, "Okay, well, he's 18."
But the parents corroborated that she was 18. So how?
Right. So again, but and again, I'm not the prosecutor. I'm just saying how you get to him violating the law. If, you know, when you look at the allegations, if they're saying that he had sex with someone who was 17, you know, it's indisputable that her, you know, her chronological age was 17, right? Like we're there, right?
Yep.
Okay, so we know that if he had sex with her when she was 17, that technically is a violation of that particular law. However, mistake of age is a defense. You understand that, right? And that's what you're
Yes.
alluding to with, oh, well, she said she was 18, parents said she was 18, police said she was 18. Okay, so that would be a legitimate mistake of age defense, right?
Yes.
Right?
Yes.
Okay. So, but then when she testifies and says there's a certain point when she was still 17 that she told him that she was 17, then he's now had sex with someone who's 17, knowing that she was 17. Now, whether
But this
you
was
disagree that was the case, I'm just going by, like, that's what the testimony was. That's all
Well,
I can go by. I can't, and that's
I
all
got
the
I got
jury
a
could go
question
by.
regarding
Like, a
that.
bunch of people have like a bunch of alternative theories and stuff, none of which went in front of the jury. And that's the only thing. I mean, it's very
and then he
difficult
never had a chance to testify, so we don't really know.
I got a
Well, he
question.
had the chance. He elected not to.
I got a question regarding that. Okay, she said that he recorded her having sex with him when she was 17 on his iPad, right?
Mhm. Yeah.
So the evidence of that recording did not come into they couldn't find that evidence to bring out that they actually had sex together
There's
when
no
she was
evidence.
17. Only thing they had was, I believe, when she was 19 on submitted as evidence from the
Okay.
iPad.
I mean, so a person can testify as to, what they perceived themselves. I mean, she had said, hey, when we would have sex, he would prop up the iPad and throw on the front facing camera and or whatever and record it. Like, you don't necessarily need the actual recording in order to establish that he was recording with the iPad. Again, I'm not saying that that's what happened or anything like that before people start jumping on me. I'm just saying what her testimony was and whether you actually need the recording on the iPad to establish that. You don't. And again, to answer, someone asked, like, have you, did you watch the trial or see the transcripts? I only read 800 pages of transcripts. I know that's not the thousands of pages that is the whole trial, but I'm not speaking on anything that I haven't read. Or it's my what I'm talking about is coming from the indictment, my over a decade of practice in law as a criminal defense attorney, and my review of these transcripts.
Okay, here's my question for you, and before we get to the final questions, you being, say this was your trial and your client has been convicted, what is the next stage for you as his attorney, or what would you be doing, preparing for? I mean, what would be your next plan of action? Even though you're not a trial attorney. Talking about you.
Well, I'm a trial attorney. I'm not an appellate attorney.
I mean, appellate attorney.
So, we're looking to see if there's any reasons for which a motion for a new trial should be filed. Ideally, I mean, it sounds like, with people, people seem to know about a lot of, information that apparently wasn't presented. And so if some further investigation needed to be done, then ideally that would have been done. So I have my team of investigators when my clients are charged with crimes, because again, I don't rely on FBI agents interviews. I don't rely on the sheriffs and police interviews because they're going to be biased. They're going to be extremely one-sided. So I have my own investigators go out and interview people and everything. And so that's how I get my statements. And sometimes they align with what, with what the police uncovered. And other times, they're different and they're less, biased, if you will. And I get a more authentic version of what actually happened. And I'm able to use that in order to either advise my client to, or actually I'm able to use that to negotiate a better deal, perhaps with the DA, because, only only like say 3 to 5% of cases actually go to trial. So 90+% of cases, result in some sort of plea agreement. A very small percentage of cases get dismissed. But so the anything that I can uncover that's going to give me a better advantage in terms of negotiating a better deal, or put me in a better position to say, all right, well, let's go to trial. Then I'm going to do that. So it sounds like, in a case like this, there's a lot of investigation that ideally should have been done. I don't know if
which
that
was not done because everything was relied from the government side.
Yeah.
Because okay. Thank you for that.
Yeah. So if that's the case, and I'm not going to sit here and speak on those defense attorneys' job, but it is clear to me that there's a lot of investigation that would have needed to be done, to put together their defense. Trevin Johnson, get this guy out of here. What are your qualifications? How many law school classes have you,
ignore them,
sat
please,
through?
please.
How many times did you pass the bar?
That's why I need you in a private line.
People come through and want to talk recklessly.
Stop.
As if I didn't, it's all good.
Ignore them.
I'm a real person here, though. You can't just be coming out here and disrespecting. That's not cool.
Thank you.
Again,
do not disrespect my guests, please. If you have something negative, you could go on out the chat. Thank you so much.
How's it going, Sylvia?
Hey, Dom. Thank
How's
you.
it going, sir?
He's given up a lot of his time. Trust me, he's expensive if I was hiring him. So for you guys to get up in here and be disrespectful, I do not appreciate it. And mods, if they do continue, please block them, or I will remove their wrench and I will block them myself. Because to be disrespectful is not good.
Mad love to him, though. I wish you a wonderful day.
I don't like stuff like that. Go ahead, Dom.
Yeah, so how's it going, sir?
All is well. I'm in beautiful San Diego. Is nice.
Exactly. Yeah, I live out that way too. So
okay, nice.
But yeah, so I like I said, I'm usually on her chat. I catch a lot. I woke up late, so I wasn't able to catch probably the first couple hours, but I was just listening. So that's why I really didn't want to come on, because I don't want to ask repetitive questions,
all good.
But just from what I've seen so far, I just wanted to ask a couple questions. One was from Dottie. She was saying, do you think social media played a huge part in him being convicted, or this case in general?
Well, in terms of the jury, I think, there was a question about, the jury potentially going on to social media or the internet, just looking up information, and judges nowadays will even be explicit and say, don't go on Facebook, don't go on, Snapchat, don't go on Instagram looking for information about this case. Don't talk about the case. Don't, you really shouldn't even be thinking about the case outside of the courtroom. And what I was saying is jurors tend to follow those instructions, but there are instances in which they don't, and they do their own research, or they do things that can be labeled as misconduct. So that's one thing in terms of the jury. The other part is in terms of just social media generally, and the media in general. A big thing is that people felt like the case had been tried in the media or on social media long before he stepped into the courtroom. And so there's nothing that you can do about what the world is talking about, right? So no attorney can go and shut down social media and shut down the media. All you can do at that point is, when you have those 50, 100, 200 people that are in the room as prospective jurors, you're going to want to ask, have you heard anything about this case? Do you have any bias against my client? Do you have any bias, against me? I'll ask these questions. I'll ask, do you have any reason to believe that, or do you just trust me? I am a young black man. Do you have any issue with black men? I understand, like, it might be uncomfortable to talk about, but if you have a prejudice against me, just by virtue of the color of my skin, don't you think that I have a right to know that, or my client should know that? And people are generally honest about their biases and their prejudices and everything. But when it comes to the issue of media and social media, then yeah, I mean, you wanna get out on voir dire and jury selection if people can only follow the law as it's presented to them, and if they can only follow the evidence that's presented to them, so they're not to consider anything outside of what is in that limited universe of what is presented to them. And so you have to trust that that they're going to do that. And I generally believe that is done. I've tried media cases. And so, I know how that goes. I can't say that I've tried anything to the extent of or magnitude of R. Kelly, just by virtue of who he is. But yeah, I mean, I want to say that, social media and, and the media would not have in and of themselves, absent evidence that they were presented that they ultimately believe were credible is what, they hung their hat on, not, people's posts or other things. But,
But don't you think that they should have fully sequestered? Because I know that they partially sequestered it, and then, for example, they started deliberating on a Friday, right?
Mhm.
And I believe they finished at Eastern time. I think it was 4 or 5 p.m. And
Yep.
she sent them home for the weekend, right? And at that point, they were
Mhm.
partially sequestered. But don't you feel that they should have been fully sequestered for that weekend until they continued deliberating? Don't you think that?
Well, I mean, it's just not really common for that to happen. And I guess you could say that this particular case is not common just by virtue of the allegations and who the defendant was. But I don't know if the defendant or if the defense argued for argued for the jury being sequestered or not. But I can't necessarily say, and again, I'm not, I didn't see the whole trial. Again, that'd be pretty problematic if I had an opportunity to, sit through thousands of pages and watch the trial, as an active defense attorney. I don't know that there's a defense attorney who's active in the nation who did all that. We got our own cases to work on, but I can't necessarily say that would have made a difference. I mean, you'd have to believe that, that there was just so much outside influence from either social media or what people watched on TV, that was that much of an influence to cause them to, decide guilty.
But you had a whole documentary, then you had, I mean, it was
Right.
a
So
lot.
again, so those are things that I have to address in voir dire. I have to, I have to ask, raise your hand if you saw Surviving R. Kelly. Raise your hand if you saw these things, and people will say, okay, yes, I did. All right. Well, if you saw that, are you able to? Well, I might, depending. I don't know what the numbers were. I don't know that it would be enough in and of itself to try and kick all the people who had seen Surviving R. Kelly. Maybe it would have been, but ultimately, I'd have to, hold their feet to the fire. And again, during voir dire, I'm digging into people because I got to make sure that my client's going to get a fair trial. So I'm asking, if you, no matter what you saw, no matter what you heard, are you able to hold the prosecution to their burden of proof? Are you able to ensure that they prove each and every element of each and every charge beyond a reasonable doubt? And unless and until I get an answer that I'm confident with, then I'm either going to kick them off for cause. I'm gonna say that, there's no way that this person can give me a fair trial, or I'm going to use my what are called peremptory challenges, where you can, just kind of kick anybody for any reason, and get them off of my jury. And so, you had very experienced lawyers there on, at least on the defense side. You had, I think one of the female defense attorneys was a former prosecutor. So I'm well, I have reason to believe that they did everything that they could to, to provide for a fair environment for their client. But to the extent if that did not happen, then those are going to be things that they're able to raise on appeal, and you know, if successfully argued, then that would result in, you know, potentially him, you know, getting a new trial or what have you.
Okay, got a question. There was a Kersey hearing in regarding to the female attorney.
There was a what?
A Kersey hearing, which had to do with misconduct, or what was it, Dottie? I forgot exactly the word. Conflict of interest.
So basically what happened,
the attorney.
Yeah, so basically what happened was there was the Kersey hearing, and I'm sure you know what that is, of course. And basically what they were saying was, so one of the attorneys, which was the female attorney, back in 2019, I guess she had spoke to Mr. Kelly's girlfriends at the time. One of them was actually, she turned against him, and she was actually in the case. And then one he's still currently dating. But I guess she had spoke on the phone with them a couple of times. And so there was a Kersey hearing saying that there was a conflict of interest. They were saying that this attorney could have been a conflict of interest. And basically her response was, no, I told them, and I made it very clear that Mr. Kelly is my client, and I'm just there with them. I'm just coming to court with them. I never gave them any type of legal advice. So if that's what you're referring to, Sylvia.
Yeah, but she also, they had an attorney, and the attorney told her not to contact them. And so she contacted them, even though the attorney told her not to. And that was a problem. And the judge even had Mr. Kelly sign off that if you be found guilty and it's because of her, you cannot say ineffective counsel, because you were already warned about her, because if it comes to her having her career and she's going to choose her career before you. So it was documented. It was signed off. The judge even got an outside attorney to be a neutral person to explain to him exactly what rights he is signing off, and he still chose to keep her on the case. So that's
exactly.
Not only
yeah,
that,
I mean,
any information that was related.
Having a conflict of interest is
they really can't hear you, Dottie. Sorry.
Yeah, I can't hear anything
sorry,
Dottie's saying.
Dottie, they can't hear because she was asking you a question.
Can you hear me?
Yeah, now I can hear you.
Well, I was saying, so any information that was related to that Jane Doe that we're talking about, any information that particular attorney had obtained that can help Rob in that case, she was not able to share that with the new attorneys. She was also not allowed, because basically he was waiving his rights to remove her as an attorney due to the unethical conduct that she had done. She was giving legal advice to these young ladies against their attorneys' wishes. But whatever she obtained that could have been used in his trial, the judge said that now it's not going to be allowed to be shared with any of the other defense attorneys because of her actions.
I'm
Nor
sorry.
would
So
later be able to come back and say,
one of his lawyers was advising alleged victims. I'm not familiar with this issue. But
yeah, no. So okay, so the woman attorney, right? Nicole. Yes. She was obviously representing him back in 2019. And she wasn't actually on the New York case, right? She was only on the Illinois. But at the time, this is when R. Kelly was just arrested and things of that nature. And the girlfriends, he had two girlfriends. They were coming to court, right? They were coming to court with him. And one of them was actually a Jane Doe. She was not a Jane Doe at that particular time. She was still defending him.
She was still a Jane Doe. She just wasn't cooperating.
Well, she wasn't cooperating. Exactly. That's my point. So sorry about that. So then half of a year later, that was when she decided to cooperate, and she, turned against him and whatever. But what she's trying to get at is this attorney was talking to the two women, just saying, hey, how's it going? This, that, and the third. But when it came out in court, they were saying that there's a curse that, they had the Kersey hearing saying that, is there a conflict of interest? And the attorney's defense, and she was saying, No, I never gave them any legal advice. I was
Yeah.
No,
just,
see,
you know,
here's the
speaking to
thing. The
them.
other attorney was telling her not to talk to their clients. That's what it was. The other attorney, Gloria, was telling her not to talk to her clients. She still continued to talk to her clients at the time.
Right.
Yeah, I mean that's.
Well, she also advised them to fire their attorney.
Yeah.
The judge.
No. The Roberts attorney told the young ladies to fire her attorney, Gloria.
Oh yeah. Yeah, I don't know that if there's a question or people just like saying that, but
No, would that be a problem? Because that would that be well, I answered my own question. Never mind.
Okay.
Yeah, I mean, if I'm defending somebody, I'm not having someone on my defense team, another lawyer, you know, reaching out and consoling anyone really. You know, I'm defending my client, so that's, you know, not, if that's, you know, directed towards me in terms of whether, you know, whether that should be done or not, then no, I don't think that should be done. I don't think there should be any conversations between the lawyers directly with any potential witnesses without the presence of my investigator. Why? Because I don't want to end up in a situation where I'm turning into a witness because I'm the only other person, you know, privy to that conversation. So I need to have my investigator either interviewing that person outside of my presence, or if I'm asking questions to or talking to on any level a potential witness, I need to have my investigator present. Because also if they try and say, well, the lawyer told me, the lawyer said this and said that, then I need to have my investigator there so that, you know, so that they're able to say, no, this is exactly what happened, or this is how it went down. So it's, yeah, that's all I can really say about that.
Okay. Well,
And then, yeah.
Go ahead, Don.
Can I just ask one more question? So just everything that you've seen so far, again, you might have answered this. Like I said, I came on late, but just from everything you've seen, all the evidence, everything that you've read, you've seen on, you know, whatever. Do you think that it was fair or legal grounds to charge one person with racketeering? That's one part of the question. And then second part is, do you think that this case was racketeering?
And
again, this isn't your opinion, just based off of the evidence or whatever and the charging. Do you think that that was fair to charge racketeering?
Yeah, no, I appreciate the question, and I did talk about this a little earlier, but I think that based on what the definitions of enterprise racketeering enterprise and racketeering are, then, you know, they can, you know, they elicited testimony to support those things, because it's not hard to establish. And again, this isn't me, you know, being a DA or anything like that. I'm a lawyer. You know, I could prosecute cases if I wanted. I'm not a prosecutor. I don't want to be. I'm a defense attorney. But, you know, in terms of, you know, this is an important point too, because I can't look at facts, and I can't look at an indictment and not be objective about it. Because if I go in the same way that perhaps a fan is, then I could be doing my client a serious disservice by either not taking a deal or taking a case to trial that needed to be taken to trial. Candy Cane, I read the superseding indictment, the one that is, you know, the indictment that he was charged on. So and who's saying it appears not to be my area of expertise? I've been a criminal defense attorney for over a decade. I don't know what you're talking about. You sound crazy.
Yeah,
but anyhow,
the comments be crazy, man.
Yeah, I mean, damn. So in terms of racketeering, racketeering is if you just think about it in a basic form, is basically organized illegal activity. So traditionally you would have, say, bootlegging or trafficking of, you know, human trafficking, drug trafficking, running numbers. Those are all different forms of racketeering. And normally you have, when you're talking about racketeering, it's usually, let's say mob cases, and I mentioned before, say Al Capone or John Gotti. Those are people that you think of when you think of racketeering. But if we're just going by what the textbook definition is, and whether you agree with it or not, really isn't relevant. No one's opinion was asked when it came to this trial. The judge's opinion didn't matter. The jurors' opinions on him or whomever, it doesn't matter. It's not based on opinion or how you feel about the law. If you want the law to be changed, then you can lobby to your legislator to get the law changed. But in terms of being able to establish that there was racketeering, if you're saying that you're using an enterprise, which again, I discussed the enterprise, just straight from the statutes. So enterprise includes any individual, partnership, corporation, association, or other legal entity. So the way that they, the evidence that they used to establish that there was an enterprise was saying that he had his runners, he had his managers, he had his security personnel, he had his engineers, all these different people that were involved in a legitimate business purpose, which was to promote his music, and then also this other illicit purpose, to commit the acts that he committed. So then so when you ask me, well, do I think it's fair? I think it's extremely unusual. It is very unusual that you would have a situation where you would use racketeering and an enterprise to describe someone who is involved in sexual assault, right? Because normally under normal circumstances, and I mentioned this before earlier, when you when you have a sexual assault case, and I use an example of an uncle with his niece, there's not a business backing that. There's not an enterprise backing that. It's just one man exploiting his family's trust by, touching a little girl or doing whatever he's doing. So you just generally don't have, it's a very unique set of facts because, you have, because most sexual assault cases, there are thousands, if not millions of them, are just committed by everyday people, none of whom actually have an entourage. But when you have somebody who does, which again, like it had a legitimate business purpose. Obviously he was, he was in the business of making music and business of promoting music and touring and all these different things. People had their jobs, but the allegations were also that he used some of these people in order to, commit these crimes, which again, if you have, say, sexual assault of a child or, kidnapping or these Mann Act violations, once you cross state lines and engage in these type of activities, that's when something can become federal. And so, yeah, like normally when you have a sexual assault case, that's not going to be a federal case. Those are usually only prosecuted as state cases. But when you're crossing state lines and doing what they call activities which affect interstate commerce, that's when really any state crime can then become federal, and that's what we have here. So admittedly it's extremely unusual that this is the way the case was charged, but some of my colleagues are a lot more offended that this is the way it was prosecuted because of the rarity of it. But just going by the textbook definitions of what racketeering is and what an enterprise is defined as, it doesn't it doesn't seem to run afoul of anything here.
But don't you think it's unfair to charge one person? Because if you look at, like you said, if you look at other RICO cases, racketeering, I've seen multiple rappers just in the past couple of years been charged with racketeering, and when you see the entire list, it's 30 people that has racketeering. And if you're saying that this man had bodyguards, security, entourage, friends, family, whatever the case may be, how are you not charging them as well? You know, not that they're guilty, but why aren't you at least charging them? I don't think that that's
well, I mean,
fair, you know?
they don't. Yeah, I get that. You know, and they don't have to have known that they were even necessarily involved in criminal activity in order for the charges to stand. And a lot of people are saying, well, why aren't they, prosecuting, the people that you mentioned? Why aren't the parents being prosecuted? All these different things. And those are valid and legitimate questions, but that doesn't necessarily take away from this one man's criminal liability. Right. I mean, I get the question, but I don't know that really changes anything. Let's just say, because also, and they may have taken deals, right? So they may have taken deals and decided to testify. I don't know those a lot of times, unless we have their testimony in which that is revealed, we wouldn't necessarily know. But I don't know that it really changes anything. I mean, let's just say all the parents were brought in and they were separately, tried and prosecuted, and the entourage, if they had knowledge that he was having sex with girls that were, not the legal age of consent, if whether they're prosecuted or not, that doesn't either take away or add to this one man's responsibility. But I get it. I mean, maybe it's a question just for thought. Yeah. So in the interest of justice, I mean, I think, for parents who are doing, I mentioned earlier, just extremely morally reprehensible acts in terms of putting their children in these situations. I think, that's a topic that, that certainly needs to be addressed. But no matter what, what that situation is, it doesn't add to or take away from his, responsibility in terms of, choosing to obey the law or not. But that's just my thought.
Okay. So, so people in the chat, this man he's a criminal defense attorney. He came on here. He spent his time. Please don't disrespect him. He's not on here for R. Kelly, and he's not against R. Kelly. He's answering these questions from a legal perspective. He's not representing R. Kelly, and he's not for the prosecution. So respect this man. He's just answering. We might not agree with some of the things. We might agree with some of the things, but he has no dog in the fight, and he's just answering the legal questions. And so to attack him like he's the prosecutor, asking him questions as if he's in that courtroom, it's not going to do anything. And it's just rude, in my opinion.
And listen,
I appreciate that.
And he has spent over 3 hours in this chat with you guys, and the least you could do is be respectful. I mean, come on.
Yeah, that is just wanting to have to provide access. I'm well aware that normally most of my friends, a lot of my friends, I'm the only attorney they know. I'm the only attorney they've ever known. And so, and I just know that traditionally, in our communities, we don't have access to attorneys. So I definitely, I give talks. I've talked to, high school students. I've talked to kids in juvenile hall. I've talked to college students. I definitely try and make myself available as much as I can to be that source of information. I know growing up, I didn't have anybody who looked like me, who was a lawyer and who I would have been able to sit down and ask these questions about. So that's why I'm here. I really don't take offense to this stuff that's being said. It's just weird to me. I just think it's weird for somebody to take the time to offer a perspective that is extremely unique. I mean, if you think about the percentage of people in the United States that are lawyers, I think it's a single digit percentage of people who are lawyers. And then when it comes to, Black people, it's even less
than that.
So, as humbly and respectfully as I can say it, I'm certainly an anomaly. And so, and now, actually haven't taken the time to go through a good deal of these transcripts, spending hours going through this stuff and the indictment and doing this. This is, this is for you, and I appreciate the love.
And I
I appreciate the
appreciate you.
invitation, Sylvia. Thank you so much. I'm not necessarily done yet, but I just wanted
No,
to
no,
say
no, I
that,
know, but
'cause
I just
I'm
don't
not,
want my
you know what I mean?
people. I need the people to understand. In my house, you got to be respectful. If that, you can
Yeah.
just leave. I'm just being serious right now.
Yeah.
Because it's not necessary. This attorney has given us so much of his time, and you guys are being very, very disrespectful, and it's not
Yeah.
right.
And
Well,
knowledge.
that's how I grew up as well. I mean,
knowledge.
I'm 41. I guess I could say I'm from the old school at this point, but yeah, I mean, a lot of times people will say stuff that they would never say to somebody, real life in their face, and I'm aware of that, and that's all good. But it's just something to think about, something to keep in perspective.
Exactly.
Well, let us know
Okay.
when you're
Someone
ready.
was asking a question about the opening statements.
Yeah.
If someone could repost that question, or
so I think what they were trying to get at was, one of the attorneys obviously had the opening statement rather, and while she was saying it, for one, she said, "Ladies and gentlemen," over 100 times. That was one thing. Two, she said, "Well, you would have to find Mr. Kelly guilty. Oh, I mean, not guilty, in order to, whatever." And then
she used to be a DA. So
exactly.
So there's that.
But it's like, you should have that, you should kind of have that prepared. And then not only that, the judge also had to alert her multiple times because she kept saying girls. So what is your, I guess what they're saying is, what do you think about that opening statement? I mean, saying that you have to find my client guilty.
Yeah, I mean, that's just we all have habits, right? And so when you've been a prosecutor for a long time, she's used to being on the other side, right? So yeah, she was a former DV prosecutor, and I'm sure she tried many cases, and it was used to saying, you should find the defendant guilty. And I don't think that in and of itself is I don't know, necessarily prejudicial to the case. I do think, if I can say this, and I don't want to say that it went as far as to prejudice him, but prosecutors see things in a certain way. And I know this by, just by having conversations with them. Also, I was an intern in the San Diego District Attorney's office for about 1.5 years. And they just have a different way of seeing things, and sometimes they can be extremely closed-minded about things, and so I know that there are some defense attorneys who sell themselves as former prosecutors, but if they have a certain way of viewing things, then it's important that if I were hiring a former prosecutor, I'd need to know, like, are you riding with me? Are you on my side? Are you really in this for me? And need to make sure that they have their mind in the right state in order to defend me and to zealously advocate on my behalf. And I'm not saying that she didn't, but that sort of slip up is just something that you don't want to see. If I'm sitting here and I'm on trial, I'm sitting here fighting for my life, and I have you saying that you need to be, that the jury needs to find me guilty, whether it's a simple slip up or not, that's going to be rough. That's going to be rough. Those are things that you don't want to hear, but yeah.
Right.
But again, I mean, that's just, habit, you know what I mean? Like you've been prosecuting cases for so many years and are just used to saying that. But I did see, I haven't seen the actual opening statements, but I did see that she was objected to. She was objected to a lot. And the issue is that there are things that you can, let's say, get away with in state court cases that you can't in federal. The rules are just different. It's a lot tighter. Excuse me, my preference, I do primarily state cases. I don't really like, I'm not a huge fan of the federal system and trying cases and defending cases on the federal side. I prefer state.
Why is that?
But for that reason, I just feel like you have a wider range in terms of things that you can do. And the biggest issue probably is the negotiations in terms of state versus federal. So what has been really complained about significantly over the years is the sentencing guidelines. And the sentencing guidelines, it basically looks like a math table. And depending on your criminal history and the seriousness of the conduct, then it's like a table, and you look, and if a person has a certain criminal history, it's going to be on this side. And then if the seriousness of the conduct, it's on this side. And then where those two numbers meet, there's a range. And then that's what the sentence is basically going to be. And you can ask for, departures and variances and everything. But for the most part, the judge is stuck, and the judge has to follow those guidelines, and they tend to, which, significantly lessens the opportunity for negotiating deals that would be much more just. And so on the state side, at least in the state of California, we don't have that. And so we can really reach a deal that adequately reflects what a case is, quote unquote, worth. And there's just a lot more flexibility in that sense. The federal law, there's so much. I know that there was, recently some federal criminal justice reform, but there's a long way to go. There's such a long way to go.
Okay. Do you think what are the I don't know if someone asked this, but what are the grounds for filing for ineffective counsel? What are the guidelines for that?
Yeah. So with ineffective assistance of counsel, you basically have to demonstrate that the lawyer's conduct fell below, what is reasonable. And that could be, any number of, specific things that they did or failed to do. And then when you have that, then there has to, the client has to have been what they call prejudiced. So in other words, but for that lawyer's conduct, then, there would have been a different outcome, so depending on, if there were certain things that the lawyers did do or failed to do, and
like
those
motions.
fell below the standard of care. What's that?
Like motion, like them not filing things on time.
Yeah.
The judge even said that they didn't miss the deadlines and things like that.
Yeah, so something like that. I mean, if you fail to file a motion on time and that ultimately, prejudiced your client, then yeah, I mean that could potentially be a ground of ineffective assistance of counsel. Absolutely.
Even like if they didn't have asked for certain things to be thrown out, and I mean they didn't make any kind of requests or anything. Everything was just lingering.
So for motions in limine, I know that there was some discussions on the record I saw in sidebars. So there were motions in limine that were filed. I can't imagine that there was just no motions filed whatsoever. That would have had to have happened. But if there was certain pieces of evidence that came in that should not have come in, and they should have argued against them coming in and failed to do so, then that would be an example of ineffective assistance of counsel. So that, if that happened, then that would certainly be a ground to raise on appeal.
Okay, see, the other thing too, the lawyers were blaming each other, like, okay, you supposed to do it, you didn't do it, this one wanted to be lead, blah, 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 blah. All that kind of craziness that was happening.
Well, the last thing you want is infighting between the defense team. It's hard enough. It's hard enough to defend a case with all you guys, in harmony and on the same page, let alone the infighting and who's going to do this, who's going to do that. Ideally, all that stuff would be sorted out and everyone would be on the same page and everybody knows their assignments and everything. It's just like, in sports, if we're running a play and the running back, sweeping out to the right and the tight end decides, well, he's not gonna throw his block, then we fail. We're gonna lose yardage. because, you know, that tight end either didn't understand the assignment or he knew the assignment, decided he wasn't going to block. So you got to have everybody on the same page or it's going to be disaster. And so, yeah, that's the thing. You know, I don't know.
Somebody just put in that they didn't file the motion for evidence against evidence of the crimes of 404B evidence. I don't know what that is, but this attorney do.
So, you know, again, I think that falls under the, you know, the broad level of what people are raising in terms of, you know, the exclusion of certain evidence that shouldn't, you know, be presented in front of the jury for whatever reasons regarding admissibility. And that was something that someone had mentioned before. And, you know, to the extent that they didn't file that and certain evidence went in front of the jury or was considered that should not have been, then, you know, then that's a problem. And that could be, you know, grounds for an allegation of ineffective assistance of counsel, which could, you know, potentially lead to a retrial. Someone mentioned in the chat about the deliberations. I had talked about that earlier, that I didn't necessarily see you know, anything about the length of the deliberations, which was about 9 hours, that really, you know, stood out to me as offensive. You know, they had a lot of witness testimony and evidence to go through. But, you know, to the extent they, you know, and 9 hours, you know, again, on a case like this, I would probably expect to see a jury out for, you know, 2 or 3 days. But, you know, sometimes the evidence is relatively clear and obviously some sort of discussion happened. It's not like they came back in 5 or 10 minutes or an hour. You know, 9 hours is not an insignificant amount of time. So that I don't see really anything wrong with that. Someone asked, did the lawyer ask or answer his opinion, guilty or not guilty? I think that would be irresponsible, given that I did not see all of the evidence. I think, you know, based on the transcripts that I did read, again, I read about 800 pages of testimony. I can see on the particular offenses that I looked at. I mean, I could see how the prosecution would have met their burden, but I'm not going to go as far as to say that this should have been, you know, a guilty verdict or not. So, you know, that, yeah, again, you know, without seeing the whole, you know, bulk of the transcripts, which would have been, you know, thousands, if not tens of thousands of pages, then, you know, you really don't have a basis to necessarily say whether a person is guilty or not. However, you know, in looking at the indictment, and this is, you know, even weeks ago when I had shot a video regarding, you know, my review of the legal issues, a lot of people were saying that, you know, well, you haven't seen the transcripts. How do you know, I don't need to see the transcripts in order to understand what the allegations are and what the testimony would be in order to prove, you know, what they're saying, because that is obvious to me as a defense attorney. Now, the micro details, yeah, I wouldn't necessarily have, but you can, I think probably even a you know, a layperson, a person who's not an attorney, would be able to look at the indictment and understand where they're going with their case and what evidence they would need to elicit to you know, to support that. But, you know, obviously at the end of the day, the jury found that there was enough information to prove beyond a reasonable doubt, despite any inconsistencies, despite, you know, any lies in the past, or, you know, any of those issues that you would use in order to raise reasonable doubt. They ultimately found that there was enough to find him guilty. And that's all I can, you know, leave with that. Thank you, Miss Fat. Appreciate it.
Okay. How often? Okay, so have you ever done an appeal?
No.
I've done maybe one appeal in my career, and I appeared in front of the Ninth Circuit and successfully won. So I'm 1 for 1 in my appeals. But I'm not an appellate attorney. I do not consider myself an appellate attorney, and I'm not. I would say I'm not really qualified to speak on appellate issues. I'm a trial attorney, so that's one thing. If I don't know something, I'm not just going to be saying stuff.
I
speaking,
appreciate that.
Yeah,
That's
so.
exactly how I am. You can't
Yeah.
speak on something you don't really know or familiar
Exactly.
with.
But there was an appeal attorney who spoke a couple weeks ago or something like that, and he did an excellent job. So he covered a lot of.
They don't pay
appellate issues.
attention. They don't pay attention. They don't pay attention because I'm like, somebody asked me, why don't you bring appeal attorney? I did. I guess they didn't pay attention.
Yeah, no, I saw it. I was gonna ask what is the how often do they do they go through, how often are they approved or successfully won, rather? Sorry.
I don't know the statistics on it, but I would say that it's a very small percentage of cases that go on appeal that are reversed on appeal, and that's just the reality of it. Yeah. Appellate courts tend to
go back
affirm.
to the other attorney. You'll see the answer.
Yeah, no, I saw it. I was just asking.
I don't know the specific statistic, but I know an overwhelming majority of cases that go up on appeal are not reversed.
Got you.
But I from the percentage, I was told 68% gets overturned.
Really?
The ones that gets to the appeal process, 68%.
Yeah, that sounds really high. I mean, I don't have the statistics, but I can't imagine that being true, to be honest with you. Who told you that?
The appeal attorney. An appeal attorney, I asked. 68% of the federal. I don't know about state, federal.
Let's all open our Google and
okay, let's open it up. Yay.
What percentage of federal criminal cases get reversed
on appeal?
Yeah, so it says on uscourts.gov, fewer than 9% of total appeals in 2015 resulted in reversals of lower courts. So yeah, again, when you said 68, I was like, whoa.
No, of the ones that was I know it's a small percentage that gets approved to go to appeal, but then the one that they actually trial gets overturned. So maybe I'm saying it the wrong way.
I don't know.
Is that like they get retried and they get overturned?
Oh, that get retried.
Yeah, go get overturned.
Yeah,
Something like that.
Okay, so that's a different issue. If you if you appeal on a certain issue and then it goes back down to the trial court. So basically you're saying something was so egregiously wrong that this should be retried or go back down to the trial court, and the case gets retried for whatever reason, then maybe at that point,
So what is that considered then? I'm confused with isn't that considered an appeal or
So you have a trial, which is what you saw in front of the evidence that's presented in front of a jury.
Mm-hmm.
After that, the appeal process is just the appellate attorneys filing briefs. So those are their legal documents pointing out all the reasons why the person was not given a fair trial, or all these issues that they're raising on appeal. The other side is going to say, well, no, this was fair. There's nothing wrong with that. And ultimately the appellant has the opportunity to file a rebuttal. And then the appellate judges, they look at the issues and then determine, whether there was anything that should or that gives rise to disturbing this particular verdict.
Mm-hmm.
And if there is, then it could be kicked back down to the trial court, or they could affirm the conviction, finding that there's no issues for which the case should be what they call remanded. That's the legal term, for which the case should be remanded. And so what this statistic is saying here, which is consistent with what I was saying, that there's a very small percentage of cases being reversed. It says here the vast majority of appeals are unsuccessful. Fewer than 9% of total appeals in 2015 resulted in reversals of lower courts. So yeah, I mean, it's just a very small percentage of cases on appeal that are successful. That's not to say that this case won't be or cannot be. Just statistically speaking, it's not typical.
Okay. Do you I don't know, like I said, I don't know if someone has asked this, but why do you think that the sentencing is so far away? Is that pretty standard, or?
I mean, in a case like this, I mean, well, there's a couple things. There's, COVID has just made everything take way longer than normal. There's a probation report that will need to be prepared. So the judge bases his or her decision on, or his sentencing ruling on a statement from the prosecution, a statement from the defense, and a statement from probation. So what probation ends up doing is they interview him. So they'll interview him about, his family history, his education history, his work history. They'll ask about the facts of the case, whether or not his attorneys advise him to go into the facts of the case, probably not. So he'll probably decline to answer any questions on that. And so based on all the information that they have, they then issue a recommendation to the judge. And then, like I said, the assistant U.S. attorneys will present their statement, and then the defense will present their statement. I imagine, in this case, there will probably be a lot of information, perhaps a psychological evaluation to be submitted to the judge. Perhaps diving into some of the trauma issues that he suffered. It's my understanding that he had been abused as a child. So that would probably come up. I mean, those are things that are what we call mitigating factors in circumstances. And so, you want to have time to get all the information that you can together, in order to, attempt to persuade the judge to, issue a particular sentence. And so, yeah, I mean, someone put the judge's calendar. I mean, that can also have something to do with it. But when it's kicked out that far, it's usually, for more serious cases, you'll have a sentence scheduled out far. But, there's also, just giving somebody the opportunity to prepare their case.
Okay.
Can I ask
And the
a
reason,
question? Hold on a second, Don. Question I have on this, as far as the sentences. Say he has fans out here that's doing things that is against the so-called victims and things like that. Will that affect his sentencing too? Go against him, or what?
He should that should not be held against him. I mean, he doesn't have any control over the actions of other people. I'd say it certainly doesn't help the situation in that sense, but the acts of other people, even if it is for his purpose, then that's probably not going to be something that's held against him.
Mm-hmm.
okay, yeah. The reason why I had asked you that regarding the sentence date is because I wanted to know about I know you're not an appellate attorney, but
Yep.
Now, does he have to be sentenced first for the appeal to actually take place, or can they start it now? What is the process of that? If you can speak on that.
So technically, a judgment has not yet been entered against him.
Okay.
And so I know, and you'll have to forgive me, but in terms of his ability to file a motion for a new trial, I mean, he would be able to do that at this point. I don't believe that he would be, able to file an appeal until the judgment has actually been entered, and then he has so much time to file, his notice of appeal, and then the appellate process starts from there.
Got you. So the soonest that he can get his appeal started is May 4th, or May 4th, 2022, basically.
Yeah, if that's the date of his sentencing hearing, then yeah, I mean, from there they would be able to file their notice of appeal, notifying the appellate courts that they're interested in appealing, and then that's the appeal process would start from there.
Okay.
Yeah, so I'm looking at this. Is it Harris? I know I've seen some Supreme Court judges make prosecutors look extremely incompetent, especially when they start going through transcripts and witness testimony. Yeah, I mean, defense attorneys as well. You have Supreme Court and appellate judges who, if you're doing things that you shouldn't be doing, or if you seem incompetent, or you're doing things that show incompetence, appellate courts will rip you apart, and rightfully so. I mean, again, we're talking about people's lives, people's freedoms in these lawyers' hands, and so we're held to a extremely high level of conduct, a standard of conduct, and and that's just something that you sign up for when you do this, and so you got to make sure you're on point. You got to make sure you put in the time. Got to make sure you're prepared and ready to go, so that you not only the preparation, but also that you have the knowledge and the skill and the expertise in order to take on the matter that you're taking on. If you're not sufficiently knowledge, or if you don't have sufficient knowledge and or skill or expertise, then you need to associate or bring somebody on who has that to make up for your incompetency. But that's another issue.
The other question I have for you, motion for reconsideration. How does that come into play? Is that something that can be done before sentencing, or how does that play?
So, to be honest with you, I've not filed any motions for reconsideration. I've filed, well, actually, I take that back. I have on other issues. So just generally speaking, when you're, if a judge has made a decision on something, so I've filed either habeas corpus petitions or motions to withdraw pleas, and a judge ends up making a ruling. Obviously, if I'm filing a motion to reconsider, they've ruled against me, and so I'm asking them to reconsider based on my belief that they got the decision wrong, based on their misinterpretation of the law or my argument or what have you. But that would be, having them, it's essentially what the name implies, having them reconsider a decision that they made. So,
but is that just done by the
someone's
bench?
asking on what grounds? I mean, it had to be something that that you felt like a decision went afoul in the trial. And so I didn't necessarily see anything from which
what about
something should be reconsidered. But
what about the jury not understanding how to apply the verdict and because I think the appeal attorney was talking something about that. If they misunderstood what the law was as it
they
applied,
also changed the word.
And then they didn't understand in the state of Illinois what the and or. I mean, it was confusion with that, so they didn't know how to apply that law.
I mean, if a jury doesn't understand something, then they they're instructed that, hey, if you don't understand something, the process is you write a note, and then that gets passed to the judge, and then what happens is the judge calls the lawyers, and they can either come in to court or they can do it over the phone.
They were confused. All three of them was confused. The judge, the defense, and the prosecutor. They spent about an hour trying to figure out which one is it.
Yeah.
It's weird.
No, I mean that happens. I mean, I think a lot of times people think that lawyers and judges are walking encyclopedias, and that's not the case. Like I don't have the whole law on all books memorized. We just did the Google search together. My job is not to just memorize rules and law. My job is to, analyze and know how I can find answers and apply, the law to facts and interpret and do those things. And so this is what happens. Like, I was discussing before in terms of the jury instructions. The jury instructions are just general instructions that go before the jury, but oftentimes, even again, right before the jury gets the instructions, there may be changes that need to be made. And sometimes, it's got to be, taken overnight, where the lawyers, the judge will say, hey, I want you to write me a brief overnight on whether this word should be included or not. And then we got to do our research and research the law and prepare a whole brief on whether, this word should be included or not. So that's not out of the ordinary, but there should be no confusion whatsoever amongst the jury when they're deliberating. And if they do have a question, then they'll provide that to the judge. The judge will provide the questions to the lawyers, and then they'll work it out, and the judge will make a ruling and then provide them the modified instruction. So in this situation where it was and or, what I was saying is that, if it should have been or instead of and, because if it's and, then you have to prove two things. If it's or, then it could be one or the other. And if it should be or, then it shouldn't be and. And so, yeah, that would be something that, could be modified even at the time that the jury is, in the room. I've had, either verdict forms or jury instructions modified. And, there are times when those rulings are not necessarily favorable to you, and sometimes they are favorable to you as the defense. Sometimes, it can go either way. It's more based on what the law is, not necessarily a judicial bias towards the prosecution or the defense. And if it is, then that's going to be, an issue that ends up, potentially going on appeal.
Okay. Dottie has a question for you.
I just wanted to ask, how do you feel the new attorneys did overall with the short amount of time that they had to prepare despite the verdict? How do you feel that they did?
I'm not qualified to say that. I'm not in the business of critiquing, lawyers' performances in that sense. But what I will say, and this came up earlier in terms of the amount of time to prepare, I just think if you only had, a few weeks, 2 or 3 weeks, or even, 2 months to prepare for a trial of this magnitude, I just don't see how that could possibly be enough time, managing your own caseload, because there's not any lawyers just kind of sitting around waiting for cases. You have your full caseload going on. Like I mentioned, I have pending drug cases, a pending attempted murder case. I've got all kinds of stuff going on. And so if this, fell into my lap, what I was saying is that, unless I had a commitment that the judge would agree to continue or allow to continue the trial, then I'm not getting on that case. I'm not going to put my client in a position where his defense is prejudiced because of whatever my motivation is to be on that case. Yeah, that's not right.
Now, kind of to your point, do you think it was irresponsible for the judge to, because knowing that he had 2 new attorneys, do you think that it was irresponsible for her not to push the trial back?
No, because when you're given a trial date, you're given a trial date. And again, we had talked about this before, but this indictment, which I read, this indictment was from December of 2019. So this case has been, going on for a while. And so
remember, he had 2 other attorneys.
Yeah, no, I get that. I'm just saying, yeah, he had attorneys on his case. And so when they're given a trial date, if you're on the case, listen, I don't get on any case that I don't plan to try and go to trial if it has to go to trial. And so yes, Sydney, trial dates can be moved, and trial dates are generally moved and can be moved, but there are times in which trial dates are not moved. And so if you're getting on a case and there's a trial date set, then you better know that you're going to be either ready for trial, or you better know that there's a good chance that you can get that moved. Otherwise, you're putting yourself in an extremely difficult position of, having less than necessary time to prepare, and even worse, you're putting your client in a position where his Sixth Amendment right to counsel is being violated, and that's it's just not okay.
Okay.
All right. So
let's see.
One final question from everybody, because I got to be considerate of your time. We at that 4-hour mark. Come on, I know you were willing to.
More than anything, I gotta use the restroom. I've been sitting this
I'm
sipping this
so
water.
sorry. Well, one last question, and I think it should come from Dom, and then I will let you go, because you've been so gracious.
Yeah, we appreciate you.
Thank you. Thank you.
Thank you, sir. I appreciate it. So this will be my final question, kind of just to wrap it up. Can and will the Illinois federal case use any of the evidence, testimony, witnesses, or any information from this current, past now, but current New York trial in their Illinois case? Can they do that?
So, I don't know. I'm not familiar with what the allegations are in that other case. So, so I'd be.
I'll send that to you, right?
Operating from ignorance on that, but in terms of whether that would potentially be violative of the rule on double jeopardy, which I think that's the direction that question goes in. The reality is people can be prosecuted in different jurisdictions for the same crime. And that gets to the multiple sovereignties doctrine, and that there are whole weeks or months related to these issues when you talk about constitutional law and everything. And I'm not going to sit here and act like I have looked at rules on double jeopardy and all that kind of stuff in a long time, because it's just not something that really comes up often. Obviously, if it's an issue in your case, then you can, you'll do your research and address it accordingly. But yeah, I would before saying whether they could present certain information or not, I would really want to know what the charges were and why, or what the charges were and what the proposed evidence is going to be.
Well, I do have that information if you want to look at it another time and come back.
All right, we'll see if we can work that out. But infamous Sylvia, I want to thank you so much, and thank you. Everyone who came with wonderful questions. You guys all asked some amazing questions. Even the people who had less than ideal things to say, God bless you as well.
You'll be all right.
But I this was fun. I went to school originally to teach, and I've taught criminal law, and it is certainly something that I'm very passionate about, and I appreciate the opportunity to do this. It's the first time, but it won't be the last. And
thank you.
We'll be in contact. All right.
Yeah, no doubt, man.
Thank you so much. Thank you. Have a great afternoon. Okay.
You have a great day, sir. Appreciate it.
All right. Thanks. Appreciate it.
Thank you. All right, guys. Let's get back. Let me see to get my people back up here. Hold on. All right. Okay, guys. Thank you so much. It's been 4 hours of lots of information. I think you guys probably got overloaded with information. Overloaded. And I know some of you guys was not too pleased with some of his answers, but it's the law. Sorry. It's the law.
Yeah, I agree. I didn't get to watch the majority of it, but yeah, people just have to keep that in mind, that's all.
And we got to get out of our emotions, y'all. We got to really get out of our emotions, because emotion is not going to win a case. Just going to tell you that right now. Facts and law.
Exactly. And I agree, Miss Fat. He is a black man at the end of the day, and he's an attorney. So can't always just attack people. He's just going.
Let me just explain something to you guys. Okay. I really have a problem with you guys. I understand you disagree with the attorney. I understand you disagree with the format or whatever. If you feel a problem, my suggestion for you is just to leave the channel. Go remove yourself, because that is going to put so much negative energy in what's supposed to be brought out. Good stuff that I don't care what anybody said. What the information this man had, it's something I did not know. And I know half of you guys, I know some of you guys may think you're lawyers, but you're not. You never passed the bar. So you have that street mentality of lawyership. But he had excellent information for you. You know, there's no need to attack him because he disagreed with you or you disagree with what he is saying. There's no need for that. I've always been told that if you don't have nothing nice to say, don't say anything at all. And that was wrong of you guys. And mods, why are you blocking for people who are not being disrespectful? That was out of order too. I was getting text messages from, I know for one person, she was not disrespectful. I know the type of messages she types. So for them to come after her and some other people, I mean, yeah, there were people being disrespectful. Those are absolutely remove their messages, and if they continue, block them. I understand those. But there were people who were not being disrespectful and they were being blocked. And I couldn't quite understand that. You understand sometimes you slip, you hit the wrong person while it's moving. I understand that. You could always put in, oh, I made a mistake, I hit the wrong person, because when the comments are moving, sometimes if you're trying to get somebody and you make a mistake and hit the wrong person, that's different. But there are people who are being blocked for no reason. And that's not fair.
Right. Yeah, and I think that's another thing too. People, like you said, get caught up in emotions and kind of forget that he's not on the case, you know? So you kind of just start asking him stuff as if he was in that courtroom. It's like he wouldn't know. He's just answering from the legal perspective, you know? So that's what I think.
And then the thing, he was limited of what I gave him. I only gave him because I was concentrating on Jane Doe number 5. So I didn't give him everything that came from the whole trial, because it wouldn't have been enough time for him to even sit here and talk to you guys, because he would still be reviewing that information. And then of the 800 pages that I've given him, he did his diligence in trying to go everything, because you heard some of the stuff he was saying. He read it, you know?
Right.
So, then you guys got to be respectful. And that goes for you too, Dom. You be just coming in here attacking and saying comments. You got to curtail some of this stuff, because we got to be professional in here for real. Seriously.
Definitely.
There are people looking at this channel, and we got to be. I mean, when I'm inviting an attorney, there's other attorneys, there's other people who's looking at this. They want to see what is at hand. Okay?
Right.
And the K Baby said, Sylvia, I came to ask about the appeal process. You told me to go back and watch the video. And when Dom asked, he went right into it and said how it works. Shake my head. But you should have came up here, K Baby, and asked. I did not know he was going. I don't cut people off when they're
asked the appeals process.
So you know, you could have came up here and asked. I wouldn't have had a problem with that. But when I was reading the messages in here, and I definitely, we did address the appeal. We had an appeal attorney to come in here, and that's why I see in these videos. That's why I bring these people, so you guys can go back and check it out. You know, and I will be bringing back that appeal attorney. He is coming back. So if you guys have questions for him, and that's the other thing. When I ask you guys to get questions, nobody submits a question, and then you get mad. I put the link in for you to come and ask the question. You still don't, then you get mad. I mean, you're damned if you do and damned if you don't. Guys, you got to work with me. Work with me, okay?
Yeah.
I'm trying to help.
He did great, though. He brought us questions that we needed to know, you know, and he answered what he could. He answered what he could. He couldn't answer what if he didn't have knowledge of it. So,
and this man has given you 4 hours, guys. 4 hours. You know how much billable hours for somebody who's an attorney? Imagine if he charged $400 an hour. We will owe him at least $1,200 right now.
Right. And see, L. Campbell, respectfully, no disrespect, but he's not an attorney. This guy, Jamahl, is actually an attorney. So just keep that in mind.
What happened? What she said? Joke, no joke, got the goods on the whole case.
I'm not trying to be funny. I'm just
hey, Dom, leave her, let her comment alone. She just voicing her opinion. Stop.
Yeah, no, nothing wrong with that. But yeah, I liked what he said. I gotta go watch the first half because, like I said, I missed probably the first 2.5, 3 hours. So,
when people have serious information, serious interviews, people want to complain and because a lot of people like drama.
Of course.
We're here to get information. We're here to get some knowledge and understanding because we felt we were railroaded in that case, period. Now we need to find out, why did these juries come up with this verdict?
Exactly. Yep. I agree. When are you having the appellate?
I'll be bringing lots of attorney coming back. Lots. There's another one coming. His big time attorney is supposed to be coming in. Waiting for him to give me the green light of when to come. I'm waiting for him. He's big, y'all. I mean, this dude is big. So you guys, if you want to play around and waste the man's money, that's on y'all. But I'm here to hear it. I'm a sponge. I want to absorb all the information.
Someone was saying that there was federal hearing today.
There was a hearing today.
What happened?
I was going to talk about that after this live. This live has been 4 hours.
No problem. Yeah.
I'm going to end this, and I need to get another one going because I said I was going to do 3 lives a day. So I'm going to end this one and start the next one. Sylvie, why did you mute Kels this morning? Why did they mute? We got to talk about that. We're going to talk about that. I'll talk to y'all about that. But anyway, let's get off this live and we'll start the next one because I got to get my 3 lives a day and 1 messy one.
L. Campbell, because I don't have to.
Okay, why are we?
All right, well, yeah. So I'll catch your next live. Great live. Thank you, attorney, for coming on. You did an awesome job.
Okay. You want to be messy? Go on the other side.
No, I'm not being messy. I was just answering the question.
Okay. All right, guys. I'm gonna end this live and I'm gonna start the next one. Okay. You need the messy? Okay, we'll do the messy in a minute. But let's see. All right, guys. See you later. Peace out.